Hello and welcome to your ultimate guide for the New Jersey Real Estate Salesperson License Examination. My goal today is simple: give you everything you need to fully understand the key concepts, master them, and walk into your exam with total confidence. In this video we'll cover real estate, contract law, property ownership, federal disclosures, land use. With over 100 plus success stories, we have proven our videos will help you pass your exam on the first attempt. And remember, our website offers free exam guides and practice questions to help you ace your exam. You'll find the link in the description below, so be sure to check it out and get the resources you need to study smarter, not harder. So let's get started.
Question 1. A buyer at a residential closing in Newark receives a federal disclosure form that itemizes the final loan terms, all settlement charges, and the cash to close. Under TRID, the lender must generally deliver this form a minimum of 3 business days before consummation. Which form best identifies this disclosure? Your options are A. The HUD-1 settlement statement, B. The loan estimate, C. The closing disclosure, D. The Truth in Lending Act notice. Which one is it? Pause the video if you need more time. The correct answer is C. The closing disclosure. C is correct because under TRID, the lender must deliver the closing disclosure to the consumer at least 3 business days before consummation of a residential mortgage. The CD replaced the legacy HUD-1 settlement statement for covered residential transactions. A is wrong because the HUD-1 settlement statement is the legacy pre-TRID closing form. It was replaced by the closing disclosure for covered residential mortgages beginning in October 2015, though it survives for a few non-TRID transactions. B is wrong because the loan estimate is the early stage TRID form delivered within 3 business days of application. It addresses estimated terms at the start of the process, not the final settlement figures at closing. D is wrong because a Truth in Lending Act notice is the prior pre-TRID disclosure document. It was largely consolidated into the loan estimate and closing disclosure under TRID for residential mortgage transactions. The closing disclosure is the federally required 5-page form that presents a borrower's final loan terms and every settlement charge before closing. It exists because the old 2-document system, a Truth in Lending disclosure plus a separate HUD-1 settlement statement, confused consumers with mismatched numbers and different categories. Congress directed the CFPB to replace those 2 legacy forms. The new integrated regime pairs the loan estimate at the front of the process with the closing disclosure at the back, so borrowers can compare estimated figures against final figures without confusion. The exam day trap is the symmetry of the 2 3-day rules. The loan estimate must be delivered within 3 business days of application. The closing disclosure must be delivered at least 3 business days before consummation, giving the borrower time to hold both forms side by side and check for surprises. The form itself lists the loan amount, interest rate, monthly payment, total cash to close, and a line-by-line accounting of every settlement charge. If a core term changes after delivery, such as the annual percentage rate jumping beyond the tolerance band, a corrected closing disclosure must issue and the 3 business day clock resets. Whenever an exam stem mentions final loan terms, cash to close, or 3 business days before consummation, that points to the closing disclosure. Front-end form after application is the loan estimate. Legacy closing form before 2015 is the HUD-1. Question 2. A New Jersey loan officer evaluates a borrower's application using the 5 C's of credit, looking at the borrower's ability to repay, willingness to repay, reserves, value of pledged property, and broader economic conditions. Which of the following correctly identifies the 5 C's in standard underwriting? Your options are A. Capacity, credit, capital, collateral conditions, B. Capacity, cost, capital, closing conditions. C. Capacity, compliance, capital, collateral, citizen. D. Compliance, credit, closing, collateral, conditions. Take a second. Which answer would you pick? The correct answer is A. Capacity, credit, capital, collateral, conditions. A is correct because the 5 C's of credit are capacity, credit, capital, collateral, and conditions. Capacity is the ability to repay. Credit is the willingness. Capital is reserves. Collateral is the property pledged. Conditions are broader market and economic factors. B is wrong because cost is not one of the 5 C's and does not replace credit in the framework. Lenders evaluate the borrower's credit history alongside capacity, capital, collateral, and conditions, not cost as an underwriting factor. C is wrong because compliance and citizenship are not among the 5 C's of credit. The 5C framework focuses on the borrower's ability and willingness to repay, available reserves, the property's collateral value, and the broader conditions. D is wrong because compliance and closing are not among the 5 C's of credit. The standard list pairs capacity and credit with capital, collateral, and conditions. Substituting closing-related terms misreads the underwriting framework. Underwriters don't make mortgage decisions with a single number. They use a 5-part framework that forces them to evaluate a borrower across 5 distinct dimensions before any loan is approved. The 5 C's are capacity, credit, capital, collateral, and conditions. Each one asks a separate question. Can the borrower repay? Will they repay? Do they have reserves? Does the property support the loan? And does the market environment make sense for the deal? Think of the underwriter working through a physical file with 5 sections. Each section holds different evidence. Income documents for capacity, the credit report for credit, bank statements for capital, the appraisal for collateral, and market data for conditions. Each C has signal words that identify it. Debt to income points to capacity. Payment history points to credit. Reserves point to capital. Appraisal value points to collateral. Market conditions or economic environment point to conditions. The most common exam trick swaps in plausible sounding C words like cost, compliance, closing, or citizenship. None of those are part of the framework. If a list includes any of them, it's wrong. The only 5 that count are capacity, credit, capital, collateral, and conditions. Question 3. A seller revokes an offer to sell a residential property in Edison before the offeree communicates acceptance. The offeree has not signed the offer or paid any consideration to hold the offer open. Which of the following best describes the legal effect of the revocation? Your options are A. The offer is irrevocable for 10 days. B. The revocation creates a counteroffer. C. The offer terminates upon revocation. D. The offeree may still accept within reason. Before I reveal it, which one do you think is right? The correct answer is C. The offer terminates upon revocation. C is correct because an offer may be revoked at any time before acceptance unless the parties have created an option supported by consideration. Once the seller communicates revocation, the offer terminates and the offeree no longer has the power to accept. A is wrong because no irrevocability applies in the absence of a paid option. An ordinary offer may be revoked at any time before acceptance, even within 10 days, unless consideration has been given to hold the offer open as an option contract. B is wrong because a revocation does not create a counteroffer. A counteroffer is the offeree's response that proposes new terms. Revocation by the offerer simply withdraws the original offer and is not a counter-proposal of any kind. D is wrong because the offeree's power to accept ends with the revocation. Acceptance after the offer has been withdrawn cannot create a contract because there is no longer any offer to accept, regardless of whether the response is otherwise reasonable. Once an offer is made, the offeree holds a power of acceptance, but that power is fragile. Understanding what kills an offer and what can lock it open is the core of contract formation in real estate. An offer grants the offeree the ability to form a contract simply by accepting, but the offeror controls that invitation. The moment revocation is communicated to the offeree, the offer dies, and no later acceptance can revive it. The critical dividing line is consideration. An ordinary offer, even one that says open for 10 days, remains revocable at the offeror's will because the offeree paid nothing to hold it open. An option contract changes that. When the offeree pays consideration, the offer becomes irrevocable for the agreed window. 4 rules govern revocation. First, the offeror may revoke any time before acceptance. Second, revocation must actually be communicated. A private change of mind is not enough. Third, indirect notice, like learning the property sold to someone else, can count. Fourth, without consideration, even a stated time period does not bind the offeror. Students often assume a stated deadline makes an offer irrevocable. It does not. Only a true option contract, backed by consideration, locks the offer open. Until consideration is paid, the offeror may withdraw at will, and any acceptance after revocation meets empty air. Question 4. A borrower's mortgage contains a clause requiring the lender to execute a release or satisfaction once the underlying debt has been paid in full. The lender must record the release to remove the mortgage lien from the property's title. Which best identifies this clause? Your options are A. Acceleration clause, B. Alienation clause, C. Subordination clause, D. Defeasance clause. What's your answer? Commit to one before I continue. The correct answer is D. Defeasance clause. D is correct because a defeasance clause obligates the lender to defeat or release the mortgage when the debt has been paid in full. The lender records a satisfaction or release to remove the mortgage lien from title and clear the public record. A is wrong because an acceleration clause lets the lender call the full balance due upon default. It addresses the borrower's breach, not the lender's obligation to release the mortgage at full payment of the underlying debt. B is wrong because an alienation clause, or due on sale clause, lets the lender call the loan due when the property is transferred. It governs response to a sale, not the lender's obligation to release the mortgage when the loan is paid off. C is wrong because a subordination clause changes lien priority between mortgages. It controls which loan is senior on title, not the lender's obligation to release the mortgage at satisfaction of the debt. A defeasance clause is the mortgage provision that obligates the lender to release its lien once the borrower has paid the debt in full. The name comes from the legal idea of defeating the lender's security interest. Once the loan is satisfied, there is nothing left to secure. In a lien theory state, the borrower keeps legal title and grants the lender a security interest. When the final payment is made, the lender must prepare a satisfaction or discharge document and record it with the county clerk, which removes the lien from the public record and returns the title to a clean state. The exam trap is confusing defeasance with 3 other clauses. Acceleration lets the lender demand the full balance on default. Alienation, or the due on sale clause, triggers when the property transfers to a new owner. Subordination adjusts lien priority between mortgages. Each clause has a different trigger. Only one fires at a time. The key is the trigger language in the facts pattern. Defeasance fires at the natural end of the loan. Acceleration fires on breach. Alienation fires on a transfer of ownership. Signal words like release, satisfaction, discharge, or clean title all point directly to defeasance. When you see a stem describing a lender releasing a lien after full payment, that is defeasance. Quiet, automatic, and essential to a clear title at the next closing. Question 5. A New Jersey salesperson licensed under a sponsoring broker enters into a personal contract directly with the consumer in the salesperson's own name, agreeing to handle the listing without the broker's involvement. Which of the following best identifies why this contract is improper? Your options are: A. Salesperson cannot contract in own name. B. Salespersons must use FHA contracts only. C. Only attorneys may sign listing agreements. D. The statute of frauds is not satisfied. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is A. Salesperson cannot contract in own name. A is correct because a New Jersey salesperson works through the sponsoring broker and cannot contract in the salesperson's own name with a consumer. Listings and brokerage agreements must run between the consumer and the firm, represented by the broker of record. B is wrong because FHA contracts are not required for residential brokerage. FHA is a loan insurance program. The issue here is that the salesperson contracted personally rather than through the firm, not the form of contract used. C is wrong because the rule does not limit listing signatures to attorneys. Licensees routinely complete and sign standard listing forms within the limits of the 1983 consent judgment. The salesperson's problem here is contracting personally, not lacking attorney status. D is wrong because the statute of frauds requires writings for certain real estate contracts. The salesperson's listing may be in writing, but the contract is still improper because the salesperson lacks authority to contract in her own name with the public. In New Jersey, real estate, the line between what a broker can do and what a salesperson can do is fundamental. Understanding the structure explains why a salesperson can never contract personally with the consumer for brokerage services. Brokers contract with the public. Salespersons contract through their broker. Every listing agreement, buyer representation agreement, and brokerage contract must run between the consumer and the firm, with the salesperson signing only as agent for that firm. On every properly executed listing, the brokerage firm's name appears at the top, the consumer signs at the bottom, and the salesperson signs on a line explicitly identifying them as agent for the firm, never as a principal in their own name. The broker's authority exists because the broker is accountable for everything the firm touches. The broker reviews paperwork, controls escrow, answers to the New Jersey Real Estate Commission, and receives the commission at closing. Allowing a salesperson to bypass the structure eliminates the supervision and consumer protection the License Act was built to guarantee. When exam facts describe a salesperson contracting in their own name without the broker, the defect is structural authority, not contract form, statute of frauds, or any other theory. The signal words are own name, without the broker, and on her own. Question 6. A residential closing in Cherry Hill triggers federal disclosure rules requiring a loan estimate within 3 business days of application and a closing disclosure at least 3 business days before consummation. Which integrated federal disclosure regime imposes these timing rules? Your options are: A. RESPA Section 8 only. B. Regulation Z and HMDA. C. TRID, TILA RESPA, Integrated Disclosures. D. Eco Regulation B. Which would you go with? Lock it in before the reveal. The correct answer is C. TRID, TILA RESPA, Integrated Disclosures. C is correct because TRID integrates the disclosures previously required by TILA and RESPA. A creditor must deliver the loan estimate within 3 business days of application and the closing disclosure at least 3 business days before consummation under Regulation Z. A is wrong because RESPA Section 8 prohibits kickbacks and unearned fees in settlement services. It does not contain the specific loan estimate and closing disclosure timing rules, which were enacted as part of the TRID integration in 2015. B is wrong because Regulation Z implements TILA, but the integrated disclosure regime with the 3-day rules is specifically TRI-D, which combines elements of TILA and RESPA. HMDA is the Home Mortgage Disclosure Act and addresses lender reporting. D is wrong because ETOA Regulation B governs equal credit opportunity and appraisal copy delivery in residential mortgages. It does not impose the loan estimate and closing disclosure timing rules that the question describes. TRID, the TILA-RESPA Integrated Disclosure Rule, is the federal framework that governs the 2 key consumer disclosures in a residential mortgage transaction. It was created by the Consumer Financial Protection Bureau under Regulation Z and took effect in October 2015. Before TRID, borrowers received separate forms under TILA and RESPA, overlapping but inconsistent, with different terminology and calculation rules. Dodd-Frank directed the CFPB to consolidate them into a single integrated regime. Once a lender receives all 6 pieces of a complete application, the 3 business day loan estimate clock starts. At the other end, the closing disclosure must be delivered at least 3 business days before consummation, giving the borrower time to compare both documents side by side. The classic exam trap is confusing TRI-D with related but distinct regimes. RESPA Section 8 bans kickbacks. Regulation Z broadly implements TILA. EQA covers discrimination. HMDA covers regulatory reporting. None of them integrates the loan estimate and closing disclosure into a single timing framework. Only TRID does. When an exam question mentions both the loan estimate and the closing disclosure timing in the same scenario, TRID is on stage. No other regime owns both 3 business day windows. Question 7. An elderly owner in Newark dies leaving no will, no spouse, no children, and no traceable heirs after diligent search by the surrogate. The county clerk records the property in the name of the state under a long-standing rule. Which government power is being applied? Your options are A. Police power, B. Eminent domain, C. Taxation, D. Escheat. Don't overthink it. Which one feels right? The correct answer is D. Escheat. D is correct because escheat transfers real property to the state when an owner dies intestate with no heirs that can be located. New Jersey law moves ownerless property to the state rather than leaving it untitled, preserving it in the public domain. A is wrong because police power regulates the use of private property through measures like zoning and building codes. It does not move title to the state and has no role in the disposition of property when an owner leaves no will or heirs. B is wrong because eminent domain takes property for public use upon payment of just compensation. The deceased owner has no heirs to compensate and the state is not acquiring property for a specific public project, which moves the matter out of eminent domain. C is wrong because taxation collects revenue through assessments and levies. It does not transfer title to the state on the death of an owner. That transfer is a function of the escheat doctrine when no heirs or will direct otherwise. Escheat is the legal doctrine that transfers real property to the state when an owner dies intestate, without a will, and no heirs can be located. It exists because every parcel of land must have an owner, and the state stands at the very back of the inheritance line. In practice, the county surrogate's office conducts a diligent search through public records, birth and marriage indexes, and prior deeds. If no will and no heirs are found, the property is recorded in the state's name under the escheat statute, and the state may then sell or repurpose it. A common exam trap is confusing escheat with the other 3 government powers over land. The mnemonic PTT captures all 4. Police power regulates use through zoning and building codes. Eminent domain takes title from a living owner with just compensation. Taxation collects revenue through assessments, and escheat moves title when no one else can take it. The signal words that point to escheat are dies intestate, no will, no heirs, ownerless property, and state succession. When those facts appear together, escheat is the doctrine at work, not eminent domain, not police power, and not taxation. Remember, escheat is the only one of the four powers where the property owner is already dead at the moment the power applies. Regulation, taking an assessment, all operate on living owners. When death without heirs moves title to the state, that is escheat. Question 8. A buyer considering a small rental property in Atlantic City asks the listing licensee why the seller believes the price reflects future rents and appreciation rather than just past performance. Which principle of value best explains why future benefits drive the present price? Your options are A. Anticipation, B. Substitution, C. Conformity, D. Contribution. Got a guess? Lock it in. The correct answer is A. Anticipation. A is correct because the principle of anticipation holds that value is the present worth of future benefits expected from ownership. Income-producing real estate is priced on projected cash flow, which is why the income approach capitalizes future net operating income into present value. B is wrong because substitution holds that a buyer will pay no more than the cost of an equally desirable substitute. It explains the ceiling effect of comparable properties, not why future expected benefits drive the present price the seller hopes to obtain. C is wrong because conformity holds that value is maximized when a property is in harmony with surrounding properties. It speaks to neighborhood character rather than to the conversion of future benefits into a present value figure. D is wrong because contribution holds that the value of an improvement is measured by what it adds to the whole property's value, not by what it cost. It analyzes incremental components rather than why projected benefits drive the overall price. The principle of anticipation holds that real property's value equals the present worth of the future benefits expected from owning it. Buyers and lenders price property on what it will generate going forward, not what it produced in the past. The income approach puts anticipation into practice. An appraiser forecasts net operating income, applies a capitalization rate reflecting market expectations and risk, and converts that future income stream into a present value today. Anticipation is one of four related appraisal principles. Substitution sets a ceiling by looking sideways at comparable sales. Contribution measures what an improvement adds to the whole. Conformity asks whether the property fits its surrounding neighborhood. Exam questions signal which principle applies through trigger language. Future benefits, projected income, and forecasted cash flow point to anticipation. Cost of a substitute points to substitution. Neighborhood harmony points to conformity. What an improvement adds points to contribution. The key insight is simple. The past is sunk. A buyer purchases the right to future rents, not a record of past ones. When a question describes projected income or expected appreciation, anticipation is on stage. Question 9. A New Jersey owner rents out a small owner-occupied 4-unit building and chooses not to use a real estate agent or discriminatory advertising. The owner declines to rent to a tenant solely because of the tenant's national origin. Which of the following best identifies the Federal Fair Housing Act treatment? Your options are A. Always exempt under federal law, B. Permitted under Civil Rights Act of 1886, C. May be exempt under Mrs. Murphy, D. Always a federal felony. Which one is it? Pause the video if you need more time. The correct answer is C. May be exempt under Mrs. Murphy. C is correct because the Mrs. Murphy exemption may apply to owner-occupied buildings of 4 or fewer units when the owner does not use a real estate agent or discriminatory advertising. The Federal Fair Housing Act exempts limited categories, but other laws still apply. A is wrong because always exempt under federal law overstates the rule. The Mrs. Murphy exemption is conditional and narrow. It does not apply if the owner uses an agent or discriminatory advertising and does not override race protections under the 1866 Act. B is wrong because permissible under the Civil Rights Act of 1866 misreads that statute. The 1866 Act bans racial discrimination in all private and public housing transactions with no exemptions. National origin is not within the 1866 Act's specific scope. D is wrong because always a federal felony overstates the consequence. Fair housing violations are typically civil offences with administrative or court remedies, not felonies, although patterns of conduct may attract criminal charges in narrow circumstances. The Mrs. Murphy exemption is a narrow carve-out under the Federal Fair Housing Act. It allows certain owner-occupied rental decisions to proceed without triggering federal liability, but only under very specific conditions. The exemption is conditional, not automatic. The building must be owner-occupied with 4 or fewer units. The owner must handle the rental personally without hiring an agent, and the owner must not place any advertising that signals a preference based on a protected class. Congress built this exemption around the idea of intimate residential association. A homeowner who actually lives alongside her tenants occupies a fundamentally different relationship than a corporate landlord managing hundreds of units from an office. The exemption disappears the moment an agent or property manager is hired, or discriminatory advertising is used. Critically, the exemption never overrides the Civil Rights Act of 1866, which bars racial discrimination in every property transaction with no exceptions. New Jersey's law against discrimination may also apply independently and is broader than the federal statute. The correct framing is always conditional. The Mrs. Murphy exemption may apply under Federal Fair Housing Act analysis, but fair housing in New Jersey is a layered analysis. Federal law, the 1866 Act, and state law each operate independently. Question 10. A New Jersey statute protects qualifying senior citizens and disabled tenants in certain converted residential buildings from eviction for an extended period and provides rent stabilization protections during conversion to condominium or cooperative ownership. Which statute best identifies this protection? Your options are A. The Real Estate Sales Full Disclosure Act, B. The Realty Transfer Fee Act, C. The Truth in Reigning Act, D. Senior Citizens and Disabled Protected Tenancy Act. Take a second. Which answer would you pick? The correct answer is D. Senior Citizens and Disabled Protected Tenancy Act. D is correct because the Senior Citizens and Disabled Protected Tenancy Act protects qualifying senior and disabled tenants in residential buildings converting to condominium or cooperative ownership. The Act provides extended protection from eviction and rent stabilization during the conversion. A is wrong because the Real Estate Sales Full Disclosure Act regulates registrations of large subdivision and out-of-state offerings. It does not protect tenants in residential buildings converting to condominium or cooperative ownership. B is wrong because the Realty Transfer Fee Act imposes a fee on the recording of deeds at closing. It is a revenue statute and does not provide protected tenancy rights for senior citizens or disabled tenants during conversion. C is wrong because the Truth in Renting Act requires landlords of certain residential rentals to provide tenants with information about rights. It does not provide the extended protected tenancy framework for seniors and disabled tenants during conversion. When a New Jersey rental building converts to condominium or cooperative ownership, vulnerable tenants face displacement. The Senior Citizens and Disabled Protected Tenancy Act was enacted specifically to prevent that outcome. To qualify, a tenant must satisfy age and income thresholds for senior status, or disability and income thresholds for the disabled category. Once protected, they cannot be evicted for owner occupancy or a unit sale, and any rent increases follow a structured, controlled process. In practice, the conversion proceeds, vacant units are sold, and non-protected tenants follow a separate timeline, but qualifying tenants remain in place. Their protections can extend up to 40 years, creating a long-term shield inside an otherwise converted building. It is easy to confuse the statute with other New Jersey laws. The Real Estate Sales Full Disclosure Act protects buyers of complex offerings, not tenants. The Realty Transfer Fee Act is a revenue measure. The Truth in Renting Act informs tenants but does not shield them. Reading the operative function from the statute's name is the fastest way to separate this family of distractors. Whenever a question signals senior citizens, disabled tenants, condominium or cooperative conversion, and extended rent stabilization, the answer points to the Senior Citizens and Disabled Protected Tenancy Act, New Jersey's substantive shield against displacement. Question 11. A buyer in Camden mails a signed acceptance of a written offer to the seller using the same method the seller used to send the original offer. Under the common law mailbox rule applied in New Jersey, when does the acceptance generally become effective as a matter of contract formation? Your options are A. When the acceptance is dispatched, B. When the seller actually receives it, C. When the seller signs the contract, D. When the deposit clears the trust account. Before I reveal it, which one do you think is right? The correct answer is A. When the acceptance is dispatched. A is correct because under the mailbox rule, an acceptance sent by a reasonable method becomes effective upon dispatch, not upon the offerer's receipt. The rule shifts the risk of delay or loss in transit to the offerer, who chose the manner of communication. B is wrong because actual receipt is not the trigger under the mailbox rule. Receipt would shift the timing risk to the offeree, which would defeat the purpose of the rule. Acceptance binds when properly dispatched, even if the offerer never receives it. C is wrong because the seller's counter-signature is not required for an acceptance to be effective when the seller is the offerer and the buyer accepts an existing offer. The mailbox rule binds the deal on dispatch of the buyer's acceptance. D is wrong because deposit clearance is a contract performance event, not a contract formation event. The contract is formed when acceptance is effective. Deposit clearance follows and is governed by escrow rules rather than offer and acceptance doctrine. The mailbox rule is a foundational common law principle governing when an acceptance actually creates a contract. Rather than waiting for the offerer to receive the acceptance, the law fixes the moment of formation at dispatch, the instant the offeree sends it through a reasonable method of communication. The rule exists to fairly allocate risk. The offerer chooses the communication channel, so the offerer is better positioned to bear the risk of delays or lost mail. Placing the trigger at dispatch, not receipt, prevents the offeree from being penalized for postal failures outside their control. Picture a buyer who signs an acceptance and drops it in the mail on Friday. The contract is formed at that moment. When the seller tries to revoke on Monday, it is already too late. The contract existed before the letter even arrived on Tuesday. Watch for 3 common wrong answers: actual receipt, which improperly shifts risk to the offeree; counter-signature of a separate document, which is unnecessary when the buyer accepts an existing offer; and deposit clearance, which is a performance event inside an already formed contract, not the formation trigger itself. The cleanest way to keep this straight: dispatch forms the contract, and everything after, inspections, deposits, closing, happens inside that already formed agreement. When a question describes the offeree sending acceptance through a reasonable channel, the mailbox rule controls, and formation is complete at the moment of sending. Question 12. A vacation property in Cape May is divided so that 26 unrelated families each hold the right to use a specific unit for 2 consecutive weeks every year, with their interests recorded as deeded fee interests in the property. Which form of ownership best describes this arrangement? Your options are A. Condominium fee ownership, B. Timeshare estate ownership, C. Cooperative stock ownership, D. A life estate pure de vie. What's your answer? Commit to one before I continue. The correct answer is B. Timeshare estate ownership. B is correct because a timeshare estate gives each owner a recorded fee interest in a unit for a recurring period each year. New Jersey regulates these arrangements under the Real Estate Timeshare Act, which requires registration of the offering. A is wrong because condominium fee ownership grants year-round fee title to a unit's airspace and an undivided share of the common elements. The owners share use of a single unit across the calendar, which is the hallmark of a timeshare. C is wrong because cooperative stock ownership gives the buyer shares in the corporation that owns the building, plus a proprietary lease for one apartment. The arrangement here vests recorded deeded fee interests in the families, not corporate stock. D is wrong because a life estate per outre vie lasts for the life of a measuring person who is not the holder. The arrangement repeats annually for 26 unrelated families and depends on no one's lifespan, ruling out any life estate. A timeshare estate is a deeded fee interest in a single unit, but instead of owning it year-round, each owner holds exclusive occupancy for a recurring calendar block, such as 2 weeks every summer. That recorded deed can be sold, mortgaged, and inherited just like any other real property interest. Resort developers created the structure to let buyers commit to ownership without paying for a full year they would never use. A single unit is split across multiple deeded owners, each recorded at the county clerk's office, sharing upkeep costs through a homeowners association fee. Because it is a true fee interest, the timeshare owner can occupy, rent, exchange, sell, or pass the interest to heirs. The same bundle of rights attached to any deeded real property. The exam trap is confusing timeshare with 3 related forms. A condominium grants year-round title to one unit's airspace. A cooperative gives corporate stock plus a proprietary lease. A life estate per outre vie lasts only for another person's life. Only the timeshare splits a single unit across multiple deeded owners by calendar block. Remember, condominium and cooperative owners divide the building spatially, each holding their unit for the entire year. Timeshare owners divide a single unit temporally, each holding it for a specific recurring block. Time versus space, and that contrast separates all 4 forms on the exam. Question 13. A New Jersey property manager handles owner trust funds across multiple owners and properties. Commingling those owner funds with the manager's own operating funds is a serious violation. Which of the following best identifies the term for spending or using owner trust funds improperly for the manager's own purposes? Your options are A. Subordination, B. Defeasance, C. Conversion, D. Foreclosure. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is C. Conversion. C is correct because conversion is the wrongful exercise of dominion over another's funds or property. including spending or using owner trust funds for the manager's own benefit. It is a serious offence that exposes the manager to civil liability and commission discipline. A is wrong because subordination changes lien priority between mortgages and is a financing concept. It has nothing to do with the misuse of owner trust funds by a property manager handling escrow. B is wrong because defeasance obligates a lender to release the mortgage when the underlying debt is paid in full. It is a mortgage clause concept and is unrelated to a property manager's misuse of trust funds. D is wrong because foreclosure is the legal process by which a lender enforces a mortgage on default. It is unrelated to a property manager's misuse of escrowed owner trust funds for personal purposes. Conversion is the legal term for wrongfully exercising dominion over someone else's funds, treating money you hold in trust as if it were your own. It's a serious offence under both common law and the New Jersey Real Estate License Act. A property manager holds owner funds in a fiduciary capacity, as a trustee, not an owner. Strict segregation rules require that owner funds stay in a dedicated trust account, completely separate from the manager's personal or operating accounts. Conversion typically surfaces from three patterns. First, commingling owner funds with personal funds and spending from the mixed pool. Second, moving owner funds to a personal account before disbursing. Third, using one owner's funds to cover another owner's shortfall. Each pattern destroys the protective segregation the trust account provides. Once a manager misuses trust funds, the conversion has already occurred, even if the money is later repaid. The wrongdoer faces civil liability, possible criminal prosecution, and commission discipline up to license revocation. Replenishing the account afterward does not erase the breach of fiduciary duty. Conversion differs from ordinary theft because the manager began with lawful possession. The wrongdoing is the misuse of funds entrusted to their care, placing it squarely within a property manager's professional duties under New Jersey license law. Question 14. A moderate income buyer wants to purchase a single-family home in a designated rural area of New Jersey using a government-backed loan with no down payment, income limits keyed to local area median income, and an upfront and annual guarantee fee. Which loan best matches this profile? Your options are A, an FHA Section 203B loan, B, a VA guaranteed loan, C, a conventional jumbo loan, D, a USDA Section 502 guaranteed loan. Which would you go with? Lock it in before the reveal. The correct answer is D, a USDA Section 502 guaranteed loan. D is correct because a USDA Section 502 guaranteed loan permits zero down financing in eligible rural areas for borrowers within income limits keyed to local area median income. The program charges an upfront guarantee fee and an annual fee in lieu of mortgage insurance. A is wrong because an FHA Section 203B loan is available without geographic limits and requires a small down payment. It is not restricted to designated rural areas and does not impose moderate income limits keyed to area median income. B is wrong because a VA guaranteed loan is restricted to eligible veterans and service members, not to geographic rural areas. Its structure includes a one-time funding fee rather than the annual guarantee fee the USDA program charges. C is wrong because a conventional jumbo loan exceeds conforming loan limits and is not government-backed. It typically requires a substantial down payment and is not the small, rural, income-limited product the question describes. The USDA Section 502 Guaranteed Loan Program is a federal mortgage product designed specifically for rural communities. It solves two problems at once. Lenders get federal backing, and borrowers get a path to home ownership with no down payment required. The loan is structured as a lender-issued mortgage backed by a USDA guarantee. The borrower pays no down payment and substitutes an upfront guarantee fee plus an annual fee in place of conventional private mortgage insurance. Eligibility requires passing 3 filters simultaneously. The property must sit in a designated rural area. The borrower's income must fall within county-specific moderate income limits tied to area median income, and the property must be a single-family home. The exam tests whether you can separate these 4 products. USDA uniquely combines rural geography, income limits, and zero down payment. FHA has no geographic filter. VA filters by military service. Conventional jumbo filters by loan size with no government backing at all. When a question stem mentions a rural area, moderate income, and no down payment together, that combination uniquely identifies the USDA Section 502 program. Reading the eligibility filter out of the stem usually points to the right product before any other detail matters. Question 15. A planning consultant in Princeton explains to a class that the municipality's master plan is the long-range policy document that guides land use, while the zoning ordinance translates that vision into binding rules. Which of the following best states the legal relationship between the two? Your options are: A. Zoning must conform to the master plan. B. The master plan binds owners as law. C. Zoning eliminates the need for a plan. D. The zoning board enacts the master plan. Don't overthink it. Which one feels right? The correct answer is A. Zoning must conform to the master plan. A is correct because under the municipal land use law, the master plan is the policy framework and the zoning ordinance is the enforceable regulation that must generally conform to the plan. The planning board prepares the plan. The governing body adopts zoning. B is wrong because the master plan is a planning document and policy guide, not a code that imposes binding rules on landowners. Enforcement requires adoption of a zoning ordinance, which is the instrument that actually regulates uses, setbacks, and heights. C is wrong because the municipal land use law requires a master plan as the planning foundation for zoning. The plan does not become unnecessary once zoning is adopted. It remains the guiding document the zoning regulations are supposed to implement. D is wrong because the Zoning Board of Adjustment hears variance and appeal matters. It does not adopt the master plan. The Planning Board prepares the master plan, and the governing body adopts the zoning ordinance, which keeps the roles separated. In New Jersey, land use law, 2 documents work together to shape how municipalities grow and develop. Understanding the difference between them is essential for any real estate professional. The master plan is a policy document. It articulates a vision for land use, housing, transportation, and conservation, but it does not directly bind landowners. The zoning ordinance is the actual law. It dictates permitted uses, building heights, density limits, and setbacks, and it must generally conform to the master plan. The municipal land use law requires that the zoning ordinance conform to the master plan. When a zoning amendment is proposed, the planning board reviews it for consistency with the plan. A material inconsistency must be justified or the plan itself must be amended to align. Watch out for 4 classic traps. The master plan does not bind landowners directly. The Zoning Board of Adjustment does not prepare the plan. The plan remains relevant after zoning is adopted. And the plan is never itself enforceable law. That role belongs exclusively to the ordinance. Keep this contrast locked in. Plans are policy prepared by planning boards with a long-range view, while ordinances are regulations adopted by governing bodies that control the parcel today. That single distinction resolves most land use questions on the exam. Question 16. The new Residential Construction Offsite Conditions Disclosure Act requires sellers of newly built homes to identify certain offsite conditions and give the buyer a specific cancellation right after delivery of the notice. How long is that statutory cancellation window in business days? Your options are A. 3 business days, B. 5 business days, C. 7 business days, D. 10 business days. Got a guess? Lock it in. The correct answer is B. 5 business days. B is correct because the new Residential Construction Offsite Conditions Disclosure Act NJSA 463C1 SEQ requires a written list of material offsite conditions and gives the buyer a 5 business day right to cancel after receiving the notice. A is wrong because 3 business days is the timing of the New Jersey attorney review period for residential contracts. It is not the cancellation window under the new Construction Offsite Conditions Statute, which provides a 5 business day period. C is wrong because 7 business days is not the statutory window for offsite conditions cancellation. The Act fixes the cancellation right at 5 business days following delivery of the offsite conditions notice to the buyer. D is wrong because 10 business days is not the cancellation period under the new Construction Offsite Conditions Statute. The buyer has 5 business days from delivery of the notice to cancel. 10 days exceeds the statutory window. New Jersey's new Residential Construction Offsite Conditions Disclosure Act requires builders to disclose conditions outside the lot lines before closing. This protection exists because new construction buyers often sign contracts before a neighborhood is built out, giving them less chance to observe the surrounding area than a resale buyer would have. The disclosure covers anything beyond the lot lines that a reasonable buyer would want to know about. Industrial facilities, transmission lines, sewer treatment plants, airports, and similar conditions. The builder researches and compiles these conditions into a written list delivered to the buyer. Once the buyer receives the written disclosure, a 5 business day cancellation window opens. Within that window, the buyer can send a notice of cancellation, which terminates the contract and returns the deposit. If the buyer does not act within 5 business days, the right lapses and the transaction moves forward. The most common exam trap is confusing this 5 business day window with other New Jersey timing rules. 3 business days applies to attorney review of residential contracts of sale and also to federal treaty closing disclosure delivery. That's both entirely separate frameworks. Only 5 business days correctly identifies the statutory cancellation period under the Offsite Conditions Disclosure Act. When an exam question signals new construction, offsite conditions, and a cancellation right, the answer is 5 business days, not 3, not 7, not 10. Matching the specific trigger to the correct window is what separates this act from every other timing rule in New Jersey real estate law. Question 17. Bulk transfer of certain New Jersey business assets, including some real estate, requires notice to the Division of Taxation on a specific form so the state can collect any unpaid taxes. Which form best identifies this bulk sale notice requirement? Your options are A. Form HUD 1, B. Schedule E, C. Form C9600, D. Form DES 99S. Which one is it? Pause the video if you need more time. The correct answer is C. Form C9600. C is correct because the New Jersey bulk sales notification is filed on Form C9600 with the Division of Taxation at least 10 business days before closing. The notice gives the state a chance to claim unpaid taxes and may result in escrow holds. A is wrong because Form HUD 1 was the legacy federal settlement statement before TREAD and is now generally replaced by the closing disclosure. It is a settlement summary, not the New Jersey bulk sales notification form. B is wrong, because Schedule E reports rental income and expenses on a federal individual tax return. It is unrelated to New Jersey bulk sales notification requirements at a real estate closing. D is wrong because Form 10-time and 10-9S reports gross proceeds from real estate transactions to the IRS. It is a federal information return, not the New Jersey Division of Taxation bulk sales notification form. When a business sells its assets in New Jersey, including certain commercial real estate, a special state law kicks in that most residential agents never encounter. This is the bulk sales notification requirement, and it exists entirely to protect unpaid state tax claims. The buyer's attorney files Form C-9600 with the Division of Taxation at least 10 business days before closing, along with the executed contract. The division then either clears the transaction or orders the buyer to escrow a specific amount covering the seller's unpaid taxes plus a cushion, so held until the division authorizes its release. The division reviews the seller's entire tax history. If it finds outstanding sales tax or withholding liabilities, it instructs the buyer to hold a specific escrow amount from the seller's proceeds. The buyer is effectively the state's safety valve, preventing a seller from disappearing with proceeds while leaving New Jersey tax debts unpaid. The classic exam trap is confusing C-9600 with other closing documents. The closing disclosure and HUD-1 are federal residential settlement statements. Schedule E reports rental income to the IRS. Former 10-9S reports gross proceeds to the IRS. None of those capture the New Jersey state tax escrow framework. Only C-9600 does. When an exam question mentions a bulk sale of business assets, 10 business days before closing, or the Division of Taxation holding an escrow, that is Form C-9600, it is a buyer-side protection mechanism, not a routine residential closing item, and it is entirely separate from any federal reporting form. Question 18. A New Jersey property manager handles a multi-unit apartment building in Hoboken and owes the owner the highest level of duty. Which mnemonic best captures the core fiduciary duties a property manager owes the owner-client under common law principles? Your options are A. Pate, B. Maria, C. Dus, D. Oldikar. Take a second. Which answer would you pick? The correct answer is D. Old car. D is correct because OLDCAR stands for obedience, loyalty, disclosure, confidentiality, accounting, and reasonable care. These common law fiduciary duties owed by an agent to a principal apply to a property manager acting on behalf of an owner-client. A is wrong because PEAT is the acronym for the 4 government powers over land: police power, eminent domain, taxation and escheat. It addresses constitutional powers, not the fiduciary duties of a property manager. B is wrong because Maria is the test for distinguishing fixtures from chattels using method of attachment, adaptation, relationship, intent, and agreement. It is not the fiduciary duty framework for property managers. C is wrong because DUST is the acronym for the 4 characteristics of economic value: demand, utility, scarcity, and transferability. It belongs to valuation theory, not to the agent's fiduciary duties to the client. In agency law, an agent owes a specific set of duties to the principal they represent. The mnemonic OLDCAR helps us remember all 6 of these common law fiduciary duties. OLDCAR stands for obedience, loyalty, disclosure, confidentiality, accounting, and reasonable care. Together, these 6 duties shape every decision an agent makes on behalf of a principal, whether that agent is a property manager, a listing agent, or a buyer's agent. All 6 duties flow from the agent toward the principal. The agent holds power on the principal's behalf, so these duties exist to ensure that power is never misused. The exam often tests whether you can match the right acronym to the right doctrine. Pete covers government powers over land. Maria identifies fixtures. And DUS covers characteristics of economic value. Only old car belongs to the fiduciary duty framework of agency law. When a question mentions fiduciary, agent, or principal, old car is your anchor. Memorizing which acronym lives in which doctrinal home is one of the highest yield moves you can make for the licensing exam. Question 19. A property owner in Newark complains that the state's new transit project so dramatically blocks all access to her storefront that the property is now nearly worthless. Yet the state never formally condemned the parcel. Which of the following remedies best describes the legal action she may pursue? Your options are A. An inverse condemnation action, B. An action for escheat reversal, C. A federal tax abatement, D. A specific performance suit. Before I reveal it, which one do you think is right? The correct answer is A. An inverse condemnation action is correct because inverse condemnation is the lawsuit a private owner brings when government action effectively takes property without formal condemnation. The owner argues the government should pay just compensation because regulation or physical impact has destroyed the practical use of the parcel. B is wrong because escheat reversal is not a recognized cause of action. Escheat is the original transfer to the state when an owner dies without heirs. The storefront owner is alive and still holds title, so escheat has no role in this situation. C is wrong because a federal tax abatement reduces a federal tax burden and is not a mechanism for recovering compensation from a state transit project. The owner's claim is about a state-imposed loss of property value, not federal taxes owed. D is wrong because specific performance is an equitable remedy compelling a party to perform a contract. There is no contract at issue here, only an alleged taking by government action that calls for a constitutional rather than contractual remedy. When the government effectively takes your property without ever filing formal condemnation proceedings, the Constitution still requires compensation. Inverse condemnation is the legal tool that enforces that requirement, putting the lawsuit in the owner's hands instead of the government's. In ordinary eminent domain, the government sues the owner to acquire title and pay compensation. Inverse condemnation flips those roles entirely. The owner sues the government to demand acknowledgement of the taking and just compensation under the Fifth Amendment. Courts recognize two main pathways to a compensable taking. A physical taking occurs when a government project floods, blocks access to, or physically impairs a parcel. A regulatory taking occurs when a restriction strips a property of all economically beneficial use, or satisfies the multi-factor Penn Central test. Consider a Newark storefront whose primary access is blocked by a newly built state rail viaduct. The state took no land formally, but the owner's property value dropped to nearly zero. This is the classic inverse condemnation scenario, a physical impairment without formal proceedings. The key distinction is always the direction of the lawsuit. Eminent domain is the government suing to take. Inverse condemnation is the owner suing to recover for a taking that already happened in effect. Both rest on the same constitutional duty to pay just compensation. Question 20. Two competing brokerage firms in Bergen County agree privately that they will both set a uniform 6% commission rate for residential listings in the same area, eliminating competitive pricing between them. Which federal antitrust violation best identifies this anti-competitive agreement? Your options are A. Tying arrangement, B. Price fixing, C. Reverse redlining, D. Bid rigging on unrelated contracts. What's your answer? Commit to one before I continue. The correct answer is B. price fixing. B is correct because price fixing is an agreement among competitors on the prices they will charge customers. It is a per se violation of the Sherman Antitrust Act and exposes the firms and their principals to criminal and civil penalties, including treble damages. A is wrong because A tying arrangement conditions sale of one product on the buyer's purchase of another. It is a separate antitrust concern, not the practice of agreeing on prices among competitors that the question describes. C is wrong because reverse redlining is a predatory lending practice that targets vulnerable borrowers in particular neighborhoods. It is a lending discrimination concept, not the antitrust price fixing agreement among competing brokerage firms. D is wrong because bid rigging on unrelated contracts is collusive conduct in bidding contexts, not the pricing agreement among brokerage firms the question describes. Both are antitrust violations, but they are different practices. Price fixing is when competing firms privately agree on the prices they'll charge customers. In real estate, this typically involves brokerage firms coordinating commission rates. It's not about what the price is it's about the agreement itself. Price fixing among real estate brokerages takes several forms. Two firms explicitly agreeing on a commission rate is the clearest case. But even informal convergence at trade association meetings or coercive threats about referrals can establish liability under the Sherman Act. Price fixing is treated as per se illegal under Section 1 of the Sherman Act, meaning courts presume it's unlawful without a full rule of reason analysis. This protects competitive markets, saves judicial resources, and sends a clear deterrent message: never coordinate prices with rivals. The critical distinction is the agreement. A firm independently setting its own commission rate is perfectly legal. The moment two competing firms coordinate on price, even informally over coffee, that agreement triggers Sherman Act liability, including criminal prosecution and treble damages. Price fixing is just one of several antitrust violations. A tying arrangement bundles one product with another, like title insurance. Reverse redlining targets vulnerable borrowers with predatory loans. Bid rigging involves collusion in bidding contexts. Each is its own distinct violation. Only price fixing involves competitors agreeing on uniform pricing terms. Question 21. A buyer asks a New Jersey licensee whether a previous occupant of the property died on the premises by suicide 3 years ago. New Jersey law generally treats this as a non-physical psychological impairment. Which of the following best identifies the licensee's disclosure obligation? Your options are A. Affirmative disclosure to every buyer always. B. Disclosure prohibited under fair housing rules. C. Disclosure not required unless buyer specifically asks. D. Disclosure required only to first-time buyers. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is C. Disclosure not required unless buyer specifically asks. C is correct because under NJAC 1156.4, a licensee need not disclose a psychological impairment such as a death on the property unless a buyer specifically asks. When asked, the licensee must answer truthfully and may also refer the buyer to inquire elsewhere. A is wrong because affirmative disclosure to every buyer always overstates the duty. New Jersey rules limit the licensee's affirmative duty in this category to circumstances where the buyer specifically asks about the issue. B is wrong because fair housing rules do not prohibit truthful answers about a death on the property. Fair housing law restricts discrimination, not the licensee's truthful response to a specific buyer question about a non-physical condition. D is wrong because no first-time buyer carve-out applies. The disclosure obligation is triggered by the buyer's specific inquiry, regardless of whether the buyer is a first-time purchaser or has previously bought property. New Jersey real estate rules treat psychological impairments, like a death on the premises, very differently from physical defects. The key is understanding exactly when a licensee must speak and when silence is permitted. The rule works in 2 steps: silence unless asked, then truthful response upon inquiry. A licensee has no duty to volunteer information about a death at open houses, in ads, or during routine showings. The buyer's specific question is the trigger that activates the duty to speak. New Jersey classifies a death on the premises as a psychological impairment, not a physical defect. Physical defects, like a sinking foundation or environmental contamination, always require disclosure. Psychological impairments do not unless the buyer specifically asks. Watch for 3 wrong framings on the exam. Universal disclosure overstates the rule. A fair housing prohibition is incorrect. Fair housing limits discrimination, not truthful factual responses. A first-time buyer carve-out simply does not exist. Only the last option correctly states the New Jersey standard. Remember the 2-step structure: no affirmative duty to volunteer, but a firm duty to answer truthfully when the buyer specifically inquires. That trigger, the buyer's question, is what makes this rule unique. Question 22. A resident in Morristown has openly used a beaten footpath across the back of a neighbor's lot for more than 20 years, continuously and without permission, to reach a public park. New Jersey law could allow a court to recognize this use as which type of property, right? Your options are A. An easement in gross by deed. B. A license that becomes a lease. C. An encroachment by acceptance. D. An easement by prescription. Which would you go with? Lock it in before the reveal. The correct answer is D. An easement by prescription. D is correct because an easement by prescription arises when use of another's land is open, notorious, continuous, hostile, and without permission for the statutory period. New Jersey courts may then recognize the long-standing path as a permanent right-of-way. A is wrong because an easement in gross requires a signed and recorded grant from the landowner to the holder of the benefit. The resident never received written permission, so the right cannot rest on a deed. It must rest on long-term adverse use. B is wrong because a license is permission the landowner may revoke at will, and that does not ripen into anything more. A lease requires a written agreement and exclusive possession, neither of which is present in a footpath used adversely for decades. C is wrong because an encroachment is an unauthorized physical structure crossing the line. A walking path leaves no permanent improvement, and the question asks what rights the long-term user might gain rather than how to end an unauthorized structure. Easement by prescription is a property right that arises not from a written grant, but from long-term, unauthorized use of another person's land. Understanding it requires knowing what conditions must be met and why the law rewards such use at all. The use must be open and notorious, continuous, hostile, and without the owner's permission. Every element functions like a checklist. If any one is missing, the claim fails. In New Jersey, these conditions must persist for 20 years. Imagine a resident who has walked a visible footpath across a neighbor's lot for over 20 years to reach a public park. The neighbor never granted permission, never erected a fence, and never objected. That pattern of open, uninterrupted, hostile use is exactly what courts look for. It helps to contrast 4 related concepts. Easement by prescription gives a use right from long-term adverse use. Adverse possession transfers full title to the occupant. A license is revocable permission that never matures into a property right. An easement in gross requires a signed, recorded grant. It cannot arise from use alone. Prescription exists because the legal system prefers to formalize long-standing arrangements rather than uproot them. When open, continuous, hostile, unpermitted use crosses the 20-year threshold in New Jersey, The courts can transform a tolerated trespass into a permanent easement. Question 23. A New Jersey brokerage firm classifies its salespersons as independent contractors rather than employees for federal tax purposes. The Internal Revenue Code provides a specific safe harbor for real estate professionals when certain conditions are met, which best identifies a key condition of the Federal Real Estate RC safe harbor. Your options are A. Compensation tied to sales output. B. The firm pays health insurance. C. The firm sets daily working hours. D. Salesperson must hold securities license. Don't overthink it. Which one feels right? The correct answer is A. Compensation tied to sales output. A is correct because the Federal Real Estate RC Safe Harbor under IRC Section 3508 requires substantially all compensation to be tied to sales output rather than hours worked, plus a written contract stating independent contractor status and a current real estate license. B is wrong because the firm paying health insurance for the salesperson cuts against RC classification. Employee benefit provision is associated with employee status, not with the RC safe harbor that lets brokerages classify salespersons as independent. C is wrong because the firm setting the salesperson's daily working hours cuts against RC classification. Detailed control over working hours points toward employee status under the common law right of control test that the IRS applies. D is wrong because no securities license is required for the real estate IC safe harbor. A current real estate license is required, but the federal safe harbor does not involve securities licensure. The Federal Real Estate Independent Contractor Safe Harbor under Internal Revenue Code, Section 3508 protects brokerage firms from federal employment tax obligations, but only when three specific conditions are satisfied. All three conditions must be met simultaneously. First, substantially all compensation, roughly 90% or more, must be tied to sales output, not hours worked. Second, a written contract must state the salesperson is not treated as an employee. Third, the salesperson must hold a current real estate license. Congress created this safe harbor because the IRS common law right of control test doesn't fit real estate well. When a firm provides office space, supplies, and training, those factors normally signal employment. But Section 3508 overrides that analysis entirely when the three conditions are satisfied. A salesperson paid entirely on commission sits squarely inside the safe harbor. A salesperson receiving a guaranteed monthly draw, salary, hourly wage, or a bonus tied to time falls outside it. Health insurance provision and daily hour control also cut against independent contractor status. They are not part of Section 3508. Section 3508 requires exactly three things: a real estate license, a written contract, and compensation tied to sales output. Health insurance, securities licenses, and hour management are not part of the safe harbor, and the federal classification has no effect on separate state law tests. Question 24. A landlocked parcel in rural Hunterdon County has the legal right to use a paved driveway across the neighbor's land to reach the public road. The right runs with the land and transfers to any future owner of the landlocked parcel. Which of the following best identifies this interest? Your options are A. An easement in gross. B. An easement appurtenant. C. A revocable license. D. A profit à prendre. Got a guess? Lock it in. The correct answer is B. An easement appurtenant. B is correct because an easement appurtenant benefits a particular parcel called the dominant estate and burdens a neighboring parcel called the servient estate. The benefit runs with the land and passes automatically to each new owner of the dominant estate. I is wrong because an easement in gross benefits a person or company rather than a parcel, such as a utilities power line. It does not depend on owning a neighboring tract, so it cannot match a right tied to a landlocked lot. C is wrong because a license is permission to enter the land that the owner can revoke at any time. It does not run with the land or transfer to future owners, which separates it from a permanent driveway easement attached to the parcel. D is wrong because a profit upfront lets the holder take something of value from the land, such as timber or minerals. It is about extraction rather than passage, and does not describe a right to cross another's land to reach a road. An easement appurtenant is a non-possessory right that permanently links two neighboring parcels. One parcel receives a benefit and the other bears a burden, and that relationship is baked into the land itself, not just the people who happen to own it. Picture a landlocked parcel that cannot reach a public road without crossing its neighbor's land. The landlocked parcel is the dominant estate. It receives the right to use the driveway. The neighbor's parcel is the servient estate. It bears that burden across its surface. Because the easement is recorded in the chain of title, it transfers automatically to every new owner of both parcels. The dominant parcel's new owner gets the benefit without a separate assignment, and the servient parcel's new owner takes the burden without a separate assumption. The easement also cannot be detached and sold apart from the dominant parcel. The exam clusters 4 related rights. An easement in gross benefits a person or company at not a parcel, like a utility corridor. A license is revocable permission that never runs with the land. A profit upfront allows extraction of timber or minerals. Only the easement appurtenant permanently benefits a neighboring parcel and runs with that land. When you see dominant estate, servient estate, and runs with the land in a fact pattern, the two-parcel structure is the giveaway. The benefit must attach to a parcel, the burden must sit on a parcel, and their link is permanent. Question 25. A buyer in Hoboken purchases a unit in a residential building and receives an interest that includes fee ownership of the airspace inside her unit and an undivided share of the lobby, hallways, roof, and grounds, all governed by a master deed and bylaws. Which form of ownership best describes this? Your options are A. Cooperative ownership, B. Timeshare estate ownership, C. Condominium ownership, D. Ownership in severalty. Which one is it? Pause the video if you need more time. The correct answer is C. Condominium ownership. C is correct because condominium ownership combines fee title to the airspace of an individual unit with an undivided interest in the common elements. New Jersey governs this form under the Condominium Act, which requires a recorded master deed and bylaws. A is wrong because cooperative ownership puts title to the entire building in a corporation. The resident owns stock and holds a proprietary lease for the unit. The buyer here takes fee title to her airspace, which separates condominium from cooperative ownership. B is wrong because a timeshare estate gives the buyer the right to occupy a unit for a recurring period each year. The question describes year-round ownership of a unit and a share of common areas, which is broader than a timeshare. D is wrong because severalty means a single person owns the entire property alone. The buyer here holds an undivided share of common areas alongside other unit owners, so the interest cannot be classified as solo severalty ownership. Condominium ownership is a distinct form of real property that combines individual fee title to a defined space with shared ownership of everything surrounding it. Understanding its structure helps you distinguish it from cooperative, timeshare, and severalty ownership. Every condominium owner holds two things simultaneously. First, fee title to the airspace inside the individual unit. Second, an undivided fractional interest in the common elements. The lobby, roof, hallways, and mechanical system that travels with the unit in every transfer. The building is legally divided by a recorded master deed, which identifies each unit, describes the common elements, and assigns each unit its percentage interest in those shared spaces. The recorded bylaws govern the association, the elected board, and the common charges that fund maintenance and reserves. The exam tests your ability to separate 4 ownership forms. Condominium pairs fee title to airspace with an undivided share of common elements. Cooperative puts building title in a corporation. Residents own stock. Timeshare grants recurring annual occupancy. Severalty means a single owner holds the entire property alone. When an exam stem mentions a master deed, bylaws, an association, common charges, or an undivided interest in common elements, the answer is condominium. No other ownership form combines individual fee title to airspace with shared title to the rest of the building. Question 26. A developer in Bergen County records a subdivision map showing 100 numbered building lots, each tied to a specific block, with public streets and easements drawn in. Future deeds in the subdivision reference only the lot, block, and recorded map. Which legal description method is in use? Your options are A. Meets and bounds, B. Government rectangular survey, C. Benchmark elevation method, D. Lot and block. Take a second. Which answer would you pick? The correct answer is D. Lot and block. D is correct because the lot and block method, also called the recorded plat method, identifies a parcel by referencing the lot and block number on a subdivision map filed with the county. It is the dominant method for residential subdivisions in New Jersey. A is wrong because meets and bounds traces a perimeter through bearings, distances, and monuments. Valid in New Jersey, it is not the method when a deed simply names a lot and block on a previously recorded subdivision map. B is wrong because the government rectangular survey overlays land with principal meridians, baselines, townships, ranges, and sections. That system organized Western public lands and was never extended over New Jersey's colonial-era boundaries. C is wrong because benchmark elevation is a vertical reference used by surveyors to establish heights above sea level. It supports a description rather than standing alone as a method for identifying the boundaries of a building lot. The lot and block method, also called the recorded plat method, is how residential subdivisions identify individual parcels without writing out full boundary measurements in every deed. Instead of tracing a perimeter, the deed simply points to a recorded map that already contains all the survey detail. When a developer records a subdivision map, it shows every lot's dimensions, bearings, distances, streets, and easements. From that point forward, each parcel in the subdivision can be identified with just 3 pieces of information: the lot number, the block number, and the name of the recorded map. A typical deed reads Lot 15, Block 4, on the map entitled Maple Estates Section 2, filed in the Bergen County Clerk's Office. Those 3 references are all that's needed. The recorded map itself supplies the precise boundary information. The exam tests all 4 description methods together. Meets and bounds traces a perimeter using bearings and distances. Government rectangular survey uses townships, ranges, and sections. It organized Western public lands but was never extended over New Jersey. Benchmark elevation is a vertical reference for height above sea level, not a boundary method at all. The critical distinction is where the spatial detail lives. In lot and block descriptions, the recorded map holds all the boundary precision. In meets and bounds, the description itself walks the perimeter. Knowing that difference will keep the 4 methods clear on exam day. Question 27. A national lender asks a New Jersey broker to prepare a broker price opinion on a residential property in foreclosure, intending to use the BPO to set the listing price for the lender-owned property. The NJREC views which documents as encompassed by the same category as the licensee CMA. Your options are A broker price opinion, BPO. B, a USPAP compliant appraisal. C, an owner's title commitment. D, an automated valuation model output. Before I reveal it, which one do you think is right? The correct answer is A, a broker price opinion, BPO. A is correct because the New Jersey Real Estate Commission and Appraiser Board treat a broker price opinion as falling within the CMA category licensees may permissibly prepare. The BPO sits inside brokerage activity and is not held out as a USPAP compliant appraisal. B is wrong because a USPAP compliant appraisal must be performed by a state licensed or state certified appraiser. A broker preparing a BPO is not performing appraisal practice and may not hold the BPO out as such an appraisal. C is wrong because an owner's title commitment is issued by a title insurance company and identifies title status. It has nothing to do with the brokerage pricing analysis the question describes, which is performed by a licensee for the lender. D is wrong because an AVM is an automated software estimate drawn from public data. It is not produced by a licensee analyzing comparable sales personally, and is a separate product from a BPO prepared by hand. A broker price opinion, or BPO, is a written estimate of property value prepared by a real estate licensee, typically for a lender, investor, or institutional client managing foreclosure inventory or asset portfolios. Both the BPO and the comparative market analysis rely on the same comparable sales technique from the MELS. Neither is held out as a USPAP compliant appraisal. That distinction belongs exclusively to licensed or certified appraisers. In a typical BPO scenario, a lender on a foreclosed property engages a licensee who pulls MLS comparables, inspects the subject property, and delivers a written report with an opinion of likely list price, all without stepping into appraisal practice. The exam tests your ability to distinguish four products: the BPO and CMA prepared by licensees, the USPAP compliant appraisal prepared only by a licensed or certified appraiser, and the automated valuation model generated by software, not by a licensee analyzing comparables personally. The key regulatory line is this: licensees prepare pricing analyses as brokerage activity, keeping them inside the License Act scope. Appraisers operate under USPAP and the Appraiser Board scope. A BPO sits firmly on the licensee's side of that line. Question 28. A small auto repair shop in Toms River has operated lawfully since the 1970s, but the surrounding area was rezoned strictly residential in 2010. The shop continues operating without expanding, structurally changing, or interrupting use. Which of the following best describes the shop's legal status? Your options are A, an illegal use that must close now. B, a legal non-conforming use subject to limits. C, a conditional use entitled to expand. D, a protected accessory structure use. What's your answer? Commit to one before I continue. The correct answer is B, a legal non-conforming use subject to limits. B is correct because a non-conforming use that lawfully existed before a zoning change may generally continue under New Jersey law, but it cannot be expanded, structurally altered, or rebuilt after destruction or abandonment without zoning relief. The shop remains a lawful non-conforming use. A is wrong because an established use that was lawful when it began is not made illegal by a later rezoning. The protection that attaches to non-conforming uses prevents the immediate closure of an existing operation, although it does not allow open-ended expansion. C is wrong because a conditional use is a use specifically listed in the ordinance as permitted, with stated conditions. The auto repair shop is not a listed conditional use in a strictly residential zone. It survives only because it predated the rezoning. D is wrong because an accessory structure is a smaller building such as a shed or garage incidental to a principal use. The auto repair shop is itself the principal use and is not protected as an accessory. Its protection comes from non-conforming use doctrine. When a zoning ordinance changes after a use has already been lawfully established, that use doesn't instantly become illegal. New Jersey law recognizes a property owner's vested interest in an activity that was perfectly legal when it started. This protection is called a legal non-conforming use. Imagine a Tom's River auto repair shop that opened when the area was zoned commercial. In 2010, the municipality rezoned the parcel residential. Because the shop predated the rezoning, it retains the right to keep operating, but only as it existed at the exact moment the ordinance changed. The protection is conditional. The shop can keep running in exactly the same form and intensity it had at rezoning, but if the owner expands operations, adds a new service bay, lets the building burn down past the destruction threshold, or closes for an extended period, the non-conforming status is lost. The doctrine balances three competing realities: the owner's investment-backed expectations, the municipality's broad power to rezone for the public interest, and the long-term goal of bringing the area into conformity. Over time, as non-conforming users naturally cease, the area gradually conforms to the new ordinance's vision. On the exam, match the fact pattern to the right category. A use lawful at inception that survives a later rezoning is a non-conforming use, not a conditional use, which is affirmatively listed in the ordinance, and not an accessory structure, which is incidental to a principal use. Expansion and abandonment are the two traps that end the protection. Question 29. A homeowner aged 65 in Atlantic City wants a non-recourse FHA-insured loan that lets her tap home equity for living expenses without making monthly payments, with the balance due upon sale, death, or permanent move-out. Which loan best matches this profile? Your options are A. A conventional second mortgage, B. A home equity line of credit, HELOC, C. A home equity conversion mortgage, HECM, D. An FHA Section 203K rehab loan. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is C. A home equity conversion mortgage, HECM. C is correct because a home equity conversion mortgage is the FHA insured reverse mortgage for home owners aged 62 or older. It is non-recourse, requires no monthly payments, and is repaid when the home is sold or the borrower dies or moves out. A is wrong because a conventional second mortgage is a fixed installment loan secured by junior position on the home, requiring monthly payments. It is not the non-recourse reverse mortgage product the question describes and does not require age qualification. B is wrong because a home equity line of credit lets the borrower draw funds up to a credit limit and requires monthly interest payments during the draw period. It is not the FHA reverse mortgage product the question seeks. D is wrong because an FHA Section 203K loan funds rehabilitation of a property as part of a purchase or refinance. It is a forward mortgage with monthly payments, not the non-recourse equity tapping reverse mortgage the question describes. A home equity conversion mortgage, or HECM, is the FHA insured reverse mortgage designed for homeowners aged 62 and older. It solves a specific retirement problem, significant home equity but constrained monthly cash flow. Many retirees are equity rich but cash poor. A conventional sale forces them to move. A home equity loan demands monthly repayment they cannot afford. The HECM lets the borrower tap equity while remaining in the home for life. Instead of the borrower paying the lender each month, the lender pays the borrower or lets interest accumulate. Repayment is deferred until the home is sold, the borrower dies, or permanently moves out. The non-recourse feature protects the borrower if the loan balance ever exceeds the home's value. The RECM is not payment-free in every sense. The borrower must occupy the home as a principal residence, maintain it, and keep property taxes and homeowners insurance current. Failing any of these obligations can trigger default and immediate loan acceleration. The exam tests your ability to distinguish four products. The HECM is the only reverse mortgage with no monthly payments during occupancy. A conventional second mortgage and a HELOC both require monthly payments and are forward loans. The FHA 203K funds property rehabilitation on a completely different purpose. Question 30. A licensee in Cherry Hill is asked by a buyer about the surrounding area school district, traffic patterns, and demographic mix. Under fair housing rules and the practice of steering, which of the following best describes the licensee's safest response framework? Your options are A. Personally describe racial makeup nearby. B. Recommend based on apparent ethnicity. C. Identify prevailing religious denomination. D. Direct buyer to objective public data. Which would you go with? Lock it in before the reveal. The correct answer is D. Direct buyer to objective public data. D is correct because steering is the practice of directing buyers toward or away from certain neighborhoods based on protected characteristics. Licensees should direct buyers to objective public data sources for demographic and neighborhood information rather than personally characterizing communities. A is wrong because personally describing the racial makeup of nearby neighborhoods crosses into steering and risks a fair housing violation. The licensee should refer buyers to objective public data rather than offer personal demographic characterizations. B is wrong because making recommendations based on the buyer's apparent ethnicity is exactly the conduct fair housing law prohibits. Steering buyers by protected characteristic exposes the licensee and the firm to civil liability and commission discipline. C is wrong because identifying the prevailing religious denomination of a neighborhood is steering by religion, a protected class. The licensee should not characterize areas by protected attributes. Objective public data sources let the buyer evaluate fit. Steering is the practice of guiding buyers toward or away from neighborhoods based on protected characteristics like race, religion, or familial status. It violates both the Federal Fair Housing Act and the New Jersey law against discrimination. Understanding why steering is harmful and how to avoid it is essential for every licensee. Steering doesn't require an outright refusal. A licensee who subtly recommends one neighborhood over another based on a buyer's apparent ethnicity, religion, or family status is steering, even if no denial is ever issued. This subtle guidance is what makes steering particularly difficult to detect and especially harmful when many licensees each make small steering decisions. The cumulative effect is residential segregation organized by protected class. Fair housing law exists precisely to break this cycle and ensure every buyer has equal access to every neighborhood. The safest response to any demographic or neighborhood character question is to point the buyer to objective public data sources. The U.S. Census Bureau publishes tract-level demographics. State agencies publish school performance and crime statistics. And municipal offices provide transit and planning data. The licensee guides access to facts, never personal characterizations. The line every licensee must hold is between objective, fact-based assistance and personal characterization by protected trade. Refer buyers to public sources, let them draw their own conclusions, and you stay on the right side of fair housing law every time. Question 31. A buyer in Hoboken takes title to a brownstone and purchases title insurance protecting against losses from undiscovered title defects existing as of the policy date. The policy stays with the buyer for as long as the buyer or successors hold ownership. Which type of title policy best fits? Your options are A. Owner's title insurance policy, B. Lender's title insurance policy, C. Mortgagee's title coverage only, D. Hazard insurance policy. Don't overthink it. Which one feels right? The correct answer is A. Owner's title insurance policy. Is correct because an owner's title insurance policy protects the buyer against losses from undiscovered title defects, generally for as long as the buyer or the buyer's heirs hold an interest. It is a one-time premium paid at closing for ongoing protection. B is wrong because a lender's title insurance policy protects the lender's mortgage interest, not the buyer's equity. It decreases as the loan is paid down and terminates when the loan is satisfied, unlike the owner's continuing protection. C is wrong because mortgagee's title coverage only is another name for lender's title insurance. It does not protect the buyer's ownership interest beyond the lender's claim and ends with payoff of the loan. D is wrong because a hazard insurance policy protects the property against fire, wind, and other casualty events. It is required at closing for mortgage property, but does not address title defects, which are insured under title insurance. An owner's title insurance policy protects a real property buyer against losses from title defects that existed before closing. It's issued at closing for a one-time premium based on the purchase price, and it stays in force for as long as the buyer or the buyer's heirs hold an interest in the property. New Jersey title carries the baggage of every prior transaction: a defect in an earlier deed, an unreleased lien, an heir whose interest was never conveyed, or a forged signature can all surface years after closing. No title search is perfect, so the owner's policy acts as the insurance backstop. At closing, two policies are typically issued side by side. The owner's policy protects the buyer's equity at the original purchase price for the entire duration of ownership. The lender's policy protects only the lender's mortgage interest and terminates once the loan is paid off. The exam tests 4 coverage types at closing. The owner's policy protects the buyer against title defects. The lender's policy, also called mortgagee's title coverage, protects only the lender's mortgage interest. Hazard insurance covers physical damage from fire or wind, not title defects. Only the owner's policy protects the buyer's equity. The key signal is always the protected party. If the stem says buyer's equity or defects existing at closing, that's the owner's policy. If it says lender's mortgage interest, that's the lender's policy. If it says fire or wind damage, that's hazard insurance. Question 32. A town council in Bergen County enacts a comprehensive ordinance that divides the municipality into zones for residential, commercial, and industrial use, sets minimum lot sizes and setback rules, and establishes maximum building heights. Which power of government best authorizes such an ordinance? Your options are A. Eminent domain, B. Police power, C. Taxation, D. A sheet. Got a guess? Lock it in. The correct answer is B. Police power. B is correct because zoning ordinances rest on the police power, which lets local government regulate land use to protect public health, safety, and welfare. New Jersey delegates this authority to municipalities through the Municipal Land Use Law, NJSA. 45 A is wrong because eminent domain is the power to take title to private property for public use upon paying just compensation. Zoning regulates how owners use their land but does not transfer title to the municipality, which separates regulation from condemnation. C is wrong because taxation is the power to raise revenue through assessments and levies. Zoning ordinances govern how property may be used rather than collect money, so taxation does not provide the constitutional basis for districting. D is wrong because escheat moves property to the state when an owner dies without heirs. It has no role in the enactment of land use districts and lot dimension standards, which arise from the regulatory police power instead. Police power is the government's constitutional authority to regulate private conduct and property in order to protect public health, safety, morals, and general welfare. Zoning ordinances, building codes, and housing maintenance codes all rest on this foundation. A governing body adopts zoning by ordinance after public hearings. The ordinance divides the municipality into use districts and sets dimensional standards, lot sizes, setbacks, height limits, in which uses are permitted, conditional, or prohibited in each zone. A critical exam concept is the four-power cluster remembered by the mnemonic PTA. Police power regulates use. Eminent domain takes tidal with just compensation. Taxation collects revenue through assessments. Escheat moves ownerless property to the state when an owner dies without heirs. Each is distinct in trigger, mechanism, and effect. The structural feature that separates police power from eminent domain is title transfer. Police power leaves title with the owner and simply regulates how the property may be used. Eminent domain physically transfers title to the government and the owner must be paid just compensation. When an exam stem describes zoning, setbacks, height limits, or use restrictions, that signals police power. When it describes the government acquiring land for a public project, that signals eminent domain. Regulation without taking title is always police power. Question 33. A real estate agent in Newark goes door to door telling homeowners in the neighborhood that property values will fall because minority families are moving into the area and urging the owners to sell quickly. Which fair housing violation best captures this prohibited practice? Your options are A. Permissible neighborhood marketing, B. Steering buyers to a neighborhood, C. Blockbusting of a neighborhood, D. Redlining of a neighborhood. Which one is it? Pause the video if you need more time. The correct answer is C. Blockbusting of a neighborhood. C is correct because blockbusting is the prohibited practice of inducing owners to sell by representing that protected class members are moving in and that values will decline. It violates the Federal Fair Housing Act and the New Jersey law against discrimination. A is wrong because permissible neighborhood marketing does not extend to scare tactics tied to protected characteristics. The conduct described as blockbusting, which is prohibited regardless of any marketing label the agent might attempt to put on it. B is wrong because steering directs buyers toward or away from particular neighborhoods based on protected characteristics. Blockbusting targets owners to induce them to sell rather than directing buyers, which is a different prohibited practice. D is wrong because redlining is the refusal to offer loans, insurance, or services to residents of certain neighborhoods. It is distinct from blockbusting, which uses scare tactics to induce owners to sell their homes. Blockbusting is a prohibited fair housing practice where someone induces homeowners to sell by claiming that members of a protected class are moving in and property values will fall. It targets sellers, and that distinction matters. Speculators would go door to door, warning residents that prices were about to crash. Panicked owners sold at depressed prices, and speculators resold to incoming families at substantial markups, transferring wealth from sellers to the speculator. Blockbusting isn't limited to in-person solicitation. Mass mailings warning of demographic change, targeted phone calls, and other scare tactics all qualify, even if the claim about who is moving in happens to be true. 3 fair housing violations share similar vocabulary: Blockbusting targets sellers to induce them to sell. Steering directs buyers toward or away from neighborhoods based on protected characteristics. Redlining refuses loans, insurance, or services to residents of certain neighborhoods. The key to keeping these straight is the direction of the manipulation. Blockbusting pushes sellers out. Steering channels buyers in or out. Redlining cuts off entire neighborhoods from services. Each has its own elements and enforcement framework under federal and New Jersey law. Question 34. A licensee in Newark sells a new construction home and recommends the buyer ask about builder warranties. New Jersey new home warranty coverage is offered through certain state programs and private warranty companies. Which statute best identifies the framework for the New Jersey New Home Warranty and Builders Registration Program? Your options are A. The Pinelands Protection Act, B. The Realty Transfer Fee Act, C. The Truth in Renting Act, D. The NJ New Home Warranty Act. Take a second. Which answer would you pick? The correct answer is D. The NJ New Home Warranty Act. D is correct because the NJ New Home Warranty and Builders Registration Act establishes warranty coverage on new home construction in defined categories and requires builder registration. Builders may participate in the state program or in approved private warranty programs. A is wrong because the Pinelands Protection Act regulates development inside the Pinelands area through the Pinelands Commission. It is a land use statute, not the warranty framework that protects buyers of newly constructed homes. B is wrong because the Realty Transfer Fee Act imposes a fee on the recording of deeds at closing in New Jersey. It is a revenue statute and has no role in providing warranties on newly constructed homes for residential buyers. C is wrong because the Truth in Renting Act requires landlords of certain residential rentals to distribute information about tenant rights. It is a landlord-tenant statute, not the new home warranty framework for residential construction in the state. The New Jersey New Home Warranty and Builders Registration Act creates a structured warranty framework for newly constructed homes, requiring builders to register with the state and offer statutory warranty coverage to every buyer at closing. The Act divides coverage into 3 tiers: 1 year for workmanship and materials, 2 years for major systems like plumbing and electrical, and 10 years for major structural defects. These periods are fixed by statute and apply whether the builder uses a state program or an approved private equivalent. When a buyer discovers a defect within the applicable period, the process is straightforward. Written notice is filed. An inspector confirms whether the defect falls within scope, and if covered, the builder repairs or compensates without the buyer needing to pursue litigation. 4 New Jersey statutes appear as distractors on the exam. Only the New Home Warranty Act creates residential construction warranty coverage. The Offsite Conditions Act governs disclosure of nearby conditions. The Realty Transfer Fee Act imposes a recording fee on deeds. And the Truth in Renting Act applies to landlord-tenant relationships, not new construction. When an exam question describes new home construction, builder registration, or warranty periods of 1, 2, or 10 years, the answer is the New Home Warranty and Builders Registration Act, not any of its common distractors. Question 35. A New Jersey listing agent learns from her seller client that the seller would accept $10,000 below the listing price if necessary to close quickly. The agent must protect this information from the buyer and the buyer's agent. Which fiduciary duty best captures this obligation? Your options are A. Confidentiality, B. Reasonable care, C. Accounting, D. Obedience. Before I reveal it, which one do you think is right? The correct answer is A. Confidentiality. A is correct because confidentiality requires the agent to keep client information private when disclosure could harm the client's bargaining position. The seller's bottom line price is classic confidential information. Disclosing it to the buyer would breach the duty. B is wrong because reasonable care requires the agent to exercise the skill and diligence reasonably expected of a competent licensee. It addresses how the agent performs services, not the obligation to keep client information secret from third parties. C is wrong because accounting requires the agent to safeguard money, documents, and other property of the client. It addresses record keeping and trust handling, not the obligation to protect a seller's bottom line price from the buyer. D is wrong because obedience requires the agent to follow the client's lawful instructions. It is about following directions, not about keeping the client's confidential pricing information from being disclosed to the buyer's side. Confidentiality is one of 6 fiduciary duties an agent owes a client, captured by the mnemonic OAD CAR. It specifically protects strategic client information from disclosure that would harm the client's bargaining position during negotiation. For a seller client, confidentiality covers the lowest acceptable price, the reason for selling, any deadline pressure, and any other information that would weaken the seller's hand at the negotiating table. The same logic protects a buyer-client's maximum offer from the buyer's agent disclosing it to the other side. The duty is asymmetric. Each agent owes confidentiality only to their own client, not to the customer on the other side. Both agents owe the other side honesty and fair dealing, but neither is required to volunteer their own client's strategic information. Confidentiality sits inside the old CAR framework alongside obedience, loyalty, disclosure, accounting, and reasonable care. Each duty is distinct. Accounting covers client money and documents, while disclosure means communicating material facts to the client, not the other side. The duty extends past the end of the agency but never covers material property defects, which must be disclosed under separate rules. When the exam stem mentions protecting strategic information from the other side, that is confidentiality, not accounting, not disclosure. Question 36. A conventional mortgage borrower in Newark makes a 10% down payment, leaving a 90% loan-to-value ratio. The lender requires the borrower to obtain insurance protecting against borrower default. Which of the following best identifies the type of coverage required? Your options are A. Hazard insurance, B. Private mortgage insurance, PMI, C. Title insurance, D. Errors and omissions insurance. What's your answer? Commit to one before I continue. The correct answer is B. Private mortgage insurance, PMI. B is correct because private mortgage insurance protects the lender against loss when a conventional borrower defaults on a high LTV loan. PMI is typically required for conventional loans with less than 20% down and can be cancelled when equity reaches the statutory threshold. A is wrong because hazard insurance protects the property against fire and other casualty. Lenders require it on all mortgages to protect the collateral, but it does not insure the lender against the borrower's default, which is the function of PMI. C is wrong because title insurance protects the lender or owner against losses from defects in title. It is required at closing on most mortgage transactions, but is unrelated to protecting the lender against borrower payment default on a high LTV loan. D is wrong because errors and omissions insurance covers professionals against claims of negligence in providing services. Real estate licensees and other professionals carry E&O coverage, but it does not protect lenders against borrower mortgage default. Private mortgage insurance, or PMI, is a specialized coverage that fills a critical gap in conventional mortgage lending. Understanding why it exists and exactly what it protects is the key to mastering this topic. PMI is required on conventional loans when the borrower puts less than 20% down, pushing the loan-to-value ratio above 80%. The borrower pays the premium monthly or upfront at closing, but the insurance protects the lender, not the borrower, against default losses. The lender sits at the center of this arrangement. When a borrower with minimal equity defaults, PMI reimburses the lender for losses on the loan principal. The borrower's equity cushion is thin, so the PMI policy fills that gap, functioning as the lender's external risk shield on a conventional loan without government backing. The critical exam distinction is knowing what each coverage insures against. PMI covers borrower default. Hazard insurance covers physical damage like fire or wind. Title insurance covers losses from defects in title. Errors and omissions insurance covers professionals against negligence claims. None of these overlap with PMI's purpose. Under the Federal Homeowners Protection Act, PMI must be cancelled automatically when amortization brings the loan-to-value ratio to 78%, or upon borrower request at 80% with a good payment history. When you see conventional loan less than 20% down, protect the lender. That's PMI. Question 37. An appraiser in Trenton explains to a homeowner that an opinion of worth formed under defined market conditions and a defined valuation date is fundamentally different from what someone actually paid or what construction would actually cost. Which of the following terms best identifies that opinion of worth? Your options are A. Price, B. Cost, C. Value, D. Markup. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is C. Value. C is correct because value is the present worth of future benefits arising from ownership, formed as an opinion under defined market conditions and a defined valuation date. Price is the amount actually paid. Cost is the dollar expenditure to produce the property. A is wrong because price is a historical fact recorded once a transaction closes, not an analytical opinion. It states what a particular buyer and seller agreed to under their own motivations, which may differ from what an appraiser opines the property is worth. B is wrong because cost is the total dollar expenditure required to build or develop the property, including hard and soft costs. It reflects production, not present worth, and a parcel can sell well above or below its cost depending on the market. D is wrong because markup is a retail concept describing the amount added to cost to produce a sale price. It is not a recognized real estate appraisal term and does not capture an analyst's defined opinion of worth as of a particular date. In real estate appraisal, three terms are often confused, but each carries a precise technical meaning. Understanding how value, price, and cost differ is essential for the licensure exam and for professional practice. Value is an analytical opinion of worth under defined market conditions on a defined date. Price is the historical amount actually paid in a specific transaction. Cost is the total expenditure required to produce or replace the property. These three numbers can differ significantly on the same property at the same moment. Value is anchored in analysis. It is an opinion, not a fact, formed using comparable sales, income capitalization, and cost approaches. Price is anchored in a single transaction and may reflect buyer or seller motivations far from market norms. Cost is anchored in production and stays independent of what the market will pay. Picture the same colonial home carrying a cost of $250,000 to build, a historical sale price of $400,000 in a hot market, and an appraiser's current value opinion somewhere in between. Three different numbers, all valid, each measuring something different. On the exam, look for the signal words. Opinion of worth and defined market conditions point to value. The amount actually paid points to price. dollar expenditure to produce points to cost. Markup is a retail term. It has no place in this analytical framework. Question 38. After the U.S. Supreme Court decided Bostock vs. Clayton County in 2020, HUD issued a 2021 memorandum interpreting the Fair Housing Act's reference to sex to encompass additional characteristics. Which of the following best identifies what the HUD memo extended the protection to cover? Your options are A. Age and economic status, B. Marital status and parenthood, C. Veteran status only, D. Sexual orientation and gender identity. Which would you go with? Lock it in before the reveal. The correct answer is D. Sexual orientation and gender identity. D is correct because the HUD Memorandum of February 11, 2021 directed the agency to interpret the Fair Housing Act's because of sex provision to encompass sexual orientation and gender identity, extending Bostock's reasoning from Title VII to fair housing enforcement. A is wrong because age and economic status are not within the Bostock-related HUD memo. The 2021 memo specifically tracked Bostock's analysis of sex discrimination to include sexual orientation and gender identity, not age or income. B is wrong because marital status and parenthood are not the specific Bostock extensions. New Jersey's own LAD covers marital status and other classes, but the HUD memo addressed sexual orientation and gender identity. C is wrong because veteran status is not within the Bostock-related HUD memo. Some state laws and other federal statutes cover veterans, but the 2021 HUD memo focused specifically on sexual orientation and gender identity. A 2021 HUD memorandum extended the Supreme Court's Bostock reasoning to the Fair Housing Act, clarifying that discrimination because of sex includes discrimination based on sexual orientation and gender identity. This built on a foundation already established in federal employment law. The Bostock decision held that you cannot discriminate based on sexual orientation or gender identity without necessarily discriminating because of sex. The HUD memo applied that same logic to the Fair Housing Act's parallel because of sex language. The Fair Housing Act prohibits discrimination on these enumerated bases. Sexual orientation and gender identity were not named explicitly. They are now covered under the sex provision through the Bostock extension, not as separate categories. The Bostock extension is narrow and specific. Age, economic status, veteran status, and marital status are not covered under this reasoning. Marital status is a New Jersey state protected class, but it is not part of the federal Bostock extension. When analyzing a Fair Housing Act question, the Bostock HUD memo applies only to sexual orientation and gender identity. Any other category requires a separate legal basis entirely. Question 39. An owner of bayfront property in Cape May County applies for a permit to build a private dock extending over a tidal flat. Title to the underwater land may be subject to a state interest under a long-standing doctrine reserving such lands. Which interest best captures the state ownership? Your options are A. Tidelands grant interest of the state, B. A federal navigation servitude, C. A municipal special assessment lien, D. A homestead exemption. Don't overthink it. Which one feels right? The correct answer is A. Tidelands grant interest of the state. A is correct because New Jersey holds title to lands now or formerly flowed by tidal waters as tidelands, subject to the public trust doctrine. A dock or fill in such areas typically needs a tidelands grant or license from the state. B is wrong because a federal navigation servitude is the federal government's authority over navigable waters and the bed beneath them. It addresses federal interests not the state ownership claim that arises under New Jersey's Tidal statute and the public trust doctrine. C is wrong because a municipal special assessment lien funds a local improvement and is recorded against benefited property. It has nothing to do with state ownership of tidally flowed underwater land, which arises from a different historical and statutory source. D is wrong because the homestead exemption protects a portion of a primary residence from certain creditors. New Jersey has no broad homestead exemption, and even where one exists, it is irrelevant to a state ownership interest in tidal bottoms. When land borders tidal water in New Jersey, the state holds a special ownership interest rooted in one of the oldest doctrines in Western law, the public trust doctrine. Understanding this principle explains why a private owner can't simply build into tidal waters without state approval. New Jersey asserts ownership of any land currently or formerly flowed by tidal water, holding it as trustee for the public. This interest traces back to Roman law and English common law, which treated tidal shores and bay bottoms as public resources, never freely alienable as ordinary private property. The boundary that matters is the mean high water line. Land seaward of that line, the foreshore and tidal bottom, falls within the state's tidelands interest. A private dock extending over that area requires a tidelands license or lease from the Department of Environmental Protection before construction can begin. The state resolves its interest through three instruments: a grant, a lease, or a license, all issued through the DEP's Tidelands program. A grant clears title to filled or formerly flowed land. A license or lease authorizes ongoing use, such as a dock over state-owned underwater areas. Three common distractors mimic the Tidelands interest but are completely different. The Federal Navigation Servitude is a federal authority over navigable waters, not a state ownership claim. A municipal special assessment lien funds a local improvement. A homestead exemption protects a primary residence from certain creditors. Only the Tidelands interest reflects New Jersey's public trust ownership of tidal land. Question 40. A landlord in Trenton seeking to evict a covered residential tenant under the Anti-Eviction Act must follow a specific statutory sequence. Which of the following best identifies the typical step that comes before a notice to quit when the ground is a curable lease violation? Your options are A. A notice of compliance recorded, B. A notice to cease, C. A federal certified mailing, D. A FEMA flood disclosure. Got a guess? Lock it in. The correct answer is B. A notice to cease. B is correct because when the ground for removal is a curable breach, the landlord must first serve a notice to cease, giving the tenant the chance to remedy the violation. If the conduct continues, the landlord then serves a notice to quit. A is wrong because no recorded notice of compliance is required as a preliminary step under the Anti-Eviction Act. The statutory framework uses a notice to cease followed by a notice to quit, not a recorded compliance notice. C is wrong because no federal certified mailing is required as a preliminary step. The Anti-Eviction Act prescribes its own notice requirements that may include personal service or specific delivery methods, but federal mailing rules do not apply. D is wrong because a FEMA flood disclosure is part of the 2024 Flood Risk Notification Law for sales and rentals. It does not precede a notice to quit in an Anti-Eviction Act eviction case. Under New Jersey's Anti-Eviction Act, landlords cannot simply file for eviction when a tenant commits a curable breach. The law requires a specific sequence of steps designed to give tenants a chance to fix the problem before losing their home. The procedural sequence has three stages. First, the notice to cease identifies the breach and demands the tenant stop. Second, if conduct continues, the landlord serves a notice to quit demanding possession. And third, the landlord files a complaint in summary dispossess proceedings in court. The notice to cease must satisfy 4 requirements. It must be in writing. It must specifically identify the breach. It must demand the conduct cease, and it must be properly served. If the tenant cures the breach within a reasonable time, the landlord cannot proceed with eviction on that ground. Not every eviction ground requires a notice to cease. Non-curable grounds, like drug-related criminal activity or threats to health and safety, skip this step entirely because there is nothing for the tenant to remedy. The notice to cease applies only where the tenant could in principle change their conduct. The key signal is curability. When an exam stem describes conduct the tenant could remedy, the notice to cease is the required predicate, not a compliance notice, not a federal mailing requirement, and not a flood disclosure. Cease comes first, quit comes second, and the complaint comes last. Question 41. A buyer in Tom's River agrees to purchase a residential property for less than the outstanding mortgage balance with the existing lender's approval. The lender agrees to accept the net sale proceeds in lieu of pursuing the borrower for the deficiency. Which transaction type best applies? Your options are A. Sheriff's sale only, B. Rio bank-owned sale, C. Short sale, D. Tax lien certificate sale. Which one is it? Pause the video if you need more time. The correct answer is C. Short sale. C is correct because a short sale occurs when the seller sells for less than the outstanding mortgage balance and the lender agrees to accept the net proceeds. The lender must approve the price and the deal. Without lender approval, the transaction cannot close. A is wrong because a sheriff's sale is the public auction held after a final judgment of foreclosure. It is part of the foreclosure process rather than the negotiated short sale transaction with the existing lender's pre-closing approval. B is wrong because an REO bank-owned sale occurs after a property has gone through foreclosure and reverted to the lender. The bank then sells the property. The question describes a pre-foreclosure short sale with the borrower still on title. D is wrong because a tax lien certificate sale is a sale of the right to collect a delinquent tax lien from the property owner. It is a tax sale rather than a negotiated mortgage short sale at the lender's approval. A short sale happens when a lender agrees to accept less than the full mortgage balance from a home sale. This requires the lender's explicit approval because the lender is giving up part of its contractual right to full repayment. Without that consent, the seller simply cannot deliver clear title. Borrowers turn to short sales when their mortgage balance exceeds what the home is worth, and circumstances make continued payments impossible. Rather than endure the long-term damage of a completed foreclosure, a short sale lets the borrower negotiate a controlled exit with the lender's cooperation. In practice, the borrower documents hardship, lists the property at market value, and submits any incoming offer to the lender for review. The lender evaluates the net proceeds after commissions and closing costs, then decides whether to release its lien, a process that can take weeks or months. The exam tests 4 distressed property transaction types. A sheriff's sale is a public auction following a foreclosure judgment. An REO sale is a bank selling a property it already took back through foreclosure. A tax lien certificate sale involves delinquent property taxes, not a mortgage at all. Only the short sale is a pre-foreclosure negotiated transaction requiring the existing lender's advance approval. The signal terms that identify a short sale are lender approval, lien release, hardship, and a sale price below the mortgage balance. If the stem describes a post-judgment auction or a bank selling its own asset, you are looking at a different transaction entirely. Question 42. A borrower in Cherry Hill makes a monthly housing payment that bundles the loan principal and interest with a 1/12th share of the annual property taxes and the annual hazard insurance premium. Which of the following best identifies this single bundled payment? Your options are discount point. B. Origination fee. C. Realty transfer fee. D. Petty payment. Take a second. Which answer would you pick? The correct answer is D. Petty payment. D is correct because petty stands for principal, interest, taxes, and insurance. A monthly petty payment lets the lender escrow the tax and insurance portions and ensures the borrower funds those obligations consistently rather than facing large annual bills. A is wrong because a discount point is a one-time payment of 1% of the loan amount made at closing to buy down the note rate. It is not a recurring monthly housing payment bundling principle, interest, taxes, and insurance. B is wrong because an origination fee compensates the lender for processing the loan and is paid at closing. It is one of several charges itemized on the closing disclosure, not the borrower's monthly bundled housing payment. C is wrong because the realty transfer fee is the New Jersey conveyance fee paid at closing on the recording of a deed. It is not a recurring monthly housing payment and has nothing to do with the lender's escrow of taxes and insurance. When you take out a mortgage, your monthly housing payment is more than just repaying the loan. It bundles 4 separate obligations into one number, which is why lenders call it petty. Principal and interest repay the mortgage loan itself. Taxes represent 1/12 of the annual property tax bill, and insurance covers 1/12 of the hazard insurance premium and any required mortgage insurance. Lenders require escrow because the property is their collateral. Unpaid property taxes can result in a tax sale that wipes out the mortgage lien, and a lapse in hazard insurance leaves the home unprotected against fire or storm damage. By collecting and paying those bills directly, the lender eliminates both risks. Each month, the borrower makes a single payment. The lender routes the principal and interest to the loan, deposits the tax and insurance shares into an escrow account, and then disperses those funds directly to the tax collector and the insurer when their bills come due. The key exam distinction is recurring versus one-time. Petty is the ongoing monthly housing payment. Discount points, origination fees, and the New Jersey realty transfer fee are all paid once at closing and never appear in the monthly payment again. Question 43. A New Jersey salesperson, without the seller's consent, tells the buyer the seller would accept any offer above a certain amount. The seller has not authorized that representation. The salesperson may have bound the broker on which theory of authority? Your options are A. Apparent authority, B. Actual express authority, C. Universal authority, D. Statutory authority. Before I reveal it, which one do you think is right? The correct answer is A. Apparent authority. A is correct because apparent authority arises when the principal's conduct leads a third party to reasonably believe the agent is authorized. If the buyer reasonably relied on the salesperson's statement, the principal can be bound even without actual authorization. B is wrong because actual express authority requires the principal to have authorized the act directly, either orally or in writing. The question states the seller did not authorize the representation, so express authority cannot be the operative theory. C is wrong because universal authority is the breadth of an agency that lets the agent do any lawful act the principal could do. It is not a theory of how an unauthorized act might bind a principal in a real estate transaction. D is wrong because statutory authority refers to powers granted by statute, such as those of a particular state office. It does not address how an unauthorized representation by a salesperson might bind the principal through reasonable reliance. Apparent authority is the doctrine that binds a principal to an agent's acts, not because the principal authorized them, but because the principal's own conduct made a third party reasonably believe the agent was authorized. Understanding this doctrine means understanding where the authorization actually flows. Apparent authority requires all three elements together. The principal must have created the appearance of authority, for example, by hiring a salesperson and putting them before the public. The third party must have reasonably believed the agent was authorized, and must have actually relied on that belief to their detriment. The critical distinction is the direction of the authority flow. Actual authority runs from the principal to the agent as a direct grant. Apparent authority runs from the principal's conduct to the third party. So, the agent may have no actual authority at all, yet the principal can still be bound. Apparent authority is commonly confused with related concepts. Actual express authority requires a direct authorization from the principal. Universal authority covers any lawful act the principal could do. Statutory authority comes from a statute. None of these explain how an unauthorized representation binds a principal through reasonable third-party reliance. The clearest way to lock in this concept, ask where the authority flows from. When the stem describes a direct grant, think actual authority. When it describes the principal's conduct creating a reasonable belief in a third party, that's apparent authority, and the principal can be bound either way. Question 44. A licensee in Newark steers a family of color away from a predominantly white neighborhood and toward a predominantly minority neighborhood, based on assumptions about where the family would prefer to live. Which fair housing concept best identifies the violation, Your options are A. Anti-blockbusting safe harbor, B. Steering by protected characteristic, C. Permissible market education, D. Designated agency under riparian. What's your answer? Commit to one before I continue. The correct answer is B. Steering by protected characteristic. B is correct because steering is the prohibited practice of directing buyers toward or away from particular neighborhoods based on a protected characteristic. It violates the Federal Fair Housing Act and the New Jersey law against discrimination. A is wrong because anti-blockbusting safe harbor does not exist as a defense to steering. Blockbusting and steering are both prohibited practices, and engaging in one is not protected because the licensee is supposedly avoiding the other. C is wrong because permissible market education does not cover directing buyers based on protected characteristics. Licensees should refer buyers to objective public data sources rather than personally characterize neighborhoods by demographics. D is wrong because designated agency under riparian is a New Jersey business relationship for infirm representation. It is unrelated to the prohibition against steering and does not authorize directing buyers based on protected characteristics. Steering is the prohibited practice of directing buyers toward or away from neighborhoods based on protected characteristics like race, national origin, religion, familial status, or disability. It violates both the Federal Fair Housing Act and the New Jersey law against discrimination. Steering works as an invisible engine of residential segregation. Even without an outright denial, a licensee who limits the homes shown based on a buyer's apparent ethnicity shapes the housing market, and the cumulative effect across many transactions is the very segregation fair housing law exists to prevent. Steering appears in several patterns, showing homes only in ethnicity-matched neighborhoods, discouraging buyers from exploring areas with different demographics, making race or religion-based assumptions about schools, and participating in any brokerage policy that channels buyers by protected class. These three violations are related but distinct. Steering directs buyers to or away from neighborhoods. Blockbusting solicits sellers using fear of protected class neighborhood change. Redlining denies services to entire geographic areas. Recognizing which cue points to which violation is the key exam skill. Critically, the doctrine reaches even well-intentioned steering. Intent does not change the discriminatory effects on housing access. If a licensee's choices limit a buyer's options based on protected characteristics, it is steering regardless of motive. Question 45. A residential real estate closing in Cherry Hill in 2026 generates a realty transfer fee collected at the time of recording the deed. Which party generally pays the basic RTF in a typical residential transaction in New Jersey? Your options are A. The buyer personally, B. The municipal tax assessor, C. The seller, grantor, D. The county clerk. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is C. The seller, grantor. C is correct because the realty transfer fee is generally paid by the seller, grantor, at the time the deed is recorded. The fee is calculated on the consideration paid and is split among state and county recipients under statute. A is wrong because the buyer typically does not pay the basic realty transfer fee. The seller pays at the time of recording. The 2025 law restructured the mansion tax surcharge to shift it onto the seller as well in residential transactions. B is wrong because the municipal tax assessor sets property assessments for ad valorem tax purposes within the municipality. The assessor does not collect or pay the realty transfer fee, which is a transfer tax obligation at recording. D is wrong because the county clerk records documents and indexes the public record at the recording office. The clerk collects the realty transfer fee from the seller at recording but does not pay the fee from county funds. The New Jersey realty transfer fee is a state-imposed charge that attaches at the moment a deed is recorded in the county clerk's office. Understanding who pays it, when and why is essential for the licensing exam. The fee is paid by the seller, the grantor, from the seller's proceeds at closing. It is calculated on the consideration shown on the deed and the affidavit of consideration, then distributed between state and county recipients by statute. In practice, the title company or closing attorney collects the fee, records the deed through the county clerk's office, and remits the funds. Recording is the critical moment. It is when the transfer becomes effective against third parties like subsequent purchasers and lien creditors. A key exam trap is confusing the four parties at closing. The seller pays the realty transfer fee. The buyer pays title insurance and lender fees. The county clerk collects and remits the fee but does not pay it. The municipal tax assessor handles property assessments, not the transfer fee. Certain transfers are partially or fully exempt, including gifts, spousal transfers, and government conveyances. Qualifying senior, blind, or disabled sellers may pay a reduced fee. The 2025 legislative change shifted the mansion tax surcharge from the buyer to the seller for high-value residential transactions. Question 46. A buyer in Cherry Hill purchases an existing residence and expects the municipality to confirm code compliance before move-in. Some New Jersey municipalities require a certificate of continued occupancy for resale of dwellings within the borders. Which of the following best identifies the source of authority for a municipal CCO requirement? Your options are A. Pinelands Commission rules, B. The Federal Should CCO program, C. Tidelands grant approval, D. Municipal property maintenance ordinances. Which would you go with? Lock it in before the reveal. The correct answer is D. Municipal property maintenance ordinances. D is correct because local property maintenance and zoning ordinances are the authority for certificate of continued occupancy programs in New Jersey. CCO requirements vary by municipality and confirm that the dwelling continues to meet basic property maintenance standards at transfer. A is wrong because Pinelands Commission rules apply only inside the Pinelands area for development controls. They do not authorize CCO programs in municipalities outside the Pinelands region or across the rest of the state. B is wrong because no federal HUD CCO program governs resale CCOs in New Jersey. HUD administers FHA and federal fair housing programs, not municipal property maintenance certification programs for resale of dwellings. C is wrong because Tidelands grant approval addresses state ownership of tidally flowed land. It has nothing to do with municipal certificate of continued occupancy requirements at the resale of a residence. A certificate of continued occupancy, or CCO, is a municipal certification that an existing dwelling meets basic property maintenance standards and is fit for occupancy at the time of resale. Unlike a certificate of occupancy for new construction, the CCO focuses on whether an older home still meets current habitability requirements. Where a municipality has adopted a CCO ordinance, the inspector typically checks items such as smoke detectors, carbon monoxide alarms, electrical safety, plumbing function, and structural integrity. The seller usually applies before closing, and the municipality either issues the certificate or requires remedial work first. In practice, the municipal building department sends an inspector to the property. If deficiencies are found, the seller makes repairs and the inspector returns to confirm fixes before the CCO is issued and closing can proceed. The critical distinction is the source of authority. CCO requirements come only from local property maintenance ordinances, WCATs, not the Pinelands Commission, which regulates Pinelands development, not HUD, which administers federal housing programs, and not Tidelands grant approval, which concerns state-owned tidal land. Only the municipality holds this authority. When a question describes a municipal certificate required at resale of an existing home, the answer is always rooted in local property maintenance ordinances. New Jersey imposes no statewide CCO requirement. Each municipality decides for itself. Question 47. A New Jersey foreclosure on a residential mortgage runs through the courts because the state requires the lender to obtain a court judgment before any sheriff's sale. Which of the following best identifies the principal court in which the foreclosure complaint is filed? Your options are A. The Superior Court Chantry Division, B. The Federal District Court in Newark, C. The Municipal Court of the Property, D. The New Jersey Real Estate Commission. Don't overthink it. Which one feels right? The correct answer is A. The Superior Court Chantry Division. A is correct because New Jersey residential foreclosures are filed in the Chantry Division of the Superior Court. The lender obtains a final judgment of foreclosure and the sheriff conducts the sale. New Jersey does not use deed of trust non-judicial procedures. B is wrong because the Federal District Court in Newark hears federal question and diversity cases. It is not the principal venue for New Jersey residential foreclosure actions, which sit in state court under the Chantry Division. C is wrong because the Municipal Court of the Property handles minor criminal and traffic matters. It has no jurisdiction over residential foreclosure actions, which require equitable jurisdiction in the Superior Court Chancery Division. D is wrong because the New Jersey Real Estate Commission regulates licensees under the License Act. It has no jurisdiction over a mortgage foreclosure between a lender and borrower. That case proceeds in the Chancery Division of the Superior Court. New Jersey is a judicial foreclosure state, which means a lender cannot simply auction a defaulted property. Every residential foreclosure must pass through the courts, providing homeowners with legal protections that non-judicial states do not require. The process follows 3 stages. The lender files a complaint in the Superior Court Chancery Division. The court reviews the lender's claims and issues a final judgment of foreclosure. Then the sheriff schedules, advertises, and conducts the auction. The Chantry Division holds equitable jurisdiction, which is exactly why foreclosure belongs there. Historically, Mortgage foreclosure is an equitable proceeding, not a common law action, so it has always lived on the equity side of the court. Only the Superior Court Chancery Division has authority over a residential foreclosure. The Federal District Court handles federal question cases, the Municipal Court handles minor criminal matters, and the Real Estate Commission regulates licensees. None of these touch a mortgage foreclosure between a lender and borrower. When an exam question describes a New Jersey residential foreclosure, the signal words are judicial state, equitable jurisdiction, complaint and judgment, and sheriff's sale. Those cues point to one place and one place only, the Superior Court Chancery Division. Question 48. A municipality in Hudson County plans to take a small strip of private property along a public road in order to widen the road for safer travel, paying the owner just compensation following appraisal and a public hearing. Which government power is the municipality exercising? Your options are A. Police power, B. Eminent domain, C. Escheat, D. Taxation. Got a guess? Lock it in. The correct answer is B. Eminent domain. B is correct because eminent domain is the power to take private property for public use upon payment of just compensation, exercised here through condemnation for a road widening. The Fifth Amendment and the New Jersey Constitution require the compensation step. A is wrong because police power regulates private property to protect the public health, safety, morals, and general welfare through measures like zoning and building codes. It does not involve government acquiring title to land, which is the distinguishing feature of eminent domain. C is wrong because escheat transfers property to the state when an owner dies without heirs or a will. It is a default mechanism for ownerless property, not an affirmative taking of an active owner's land for a public project like a road widening. D is wrong because taxation raises revenue through real property assessments and other levies. The municipality here is acquiring physical land for a public project rather than collecting money, which moves the exercise from taxation into eminent domain. Eminent domain is the constitutional power of government to take private property for public use, but only after paying the owner just compensation. This authority flows from both the Fifth Amendment and the New Jersey Constitution, and it's exercised through a formal legal process called condemnation. In practice, the condemning authority follows a step-by-step statutory process. The agency appraises the parcel, makes an offer, and negotiates. If the owner refuses, the agency files a condemnation petition in court, where commissioners or a jury determine fair market value. Matisate, and the agency deposits that amount before taking possession. Just compensation equals fair market value at the date of taking. Appraisers typically rely on three recognized approaches: comparable sales, income capitalization, and the cost approach. When only part of a parcel is taken, the owner may also recover severance damages for any drop in value to the remaining land. A classic exam trap groups eminent domain with three other government powers under the mnemonic PEAT: police power, eminent domain, taxation, and escheat. The key distinction: only eminent domain transfers title to an active owner's land, and only eminent domain requires payment of just compensation. When an exam stem mentions taking private property for a public project with compensation, that's eminent domain. Regulation of use points to police power, revenue collection points to taxation, heirless property passing to the state points to escheat. Keep the structural difference clear and you'll never confuse them. Question 49. A New Jersey licensee orienting a new buyer client at the first showing must provide a state-prescribed document describing the available business relationships available to consumers. The document must be delivered at the first substantive contact about a specific property. Which document best identifies the state-required disclosure? Your options are A. The closing disclosure, B. The loan estimate, C. The consumer information statement, CIS, D. The seller's property condition disclosure. Which one is it? Pause the video if you need more time. The correct answer is C. The consumer information statement, CES. C is correct because the consumer information statement on New Jersey real estate relationships, prescribed by NJAC, Lava 569, describes the available business relationships and must be provided at the first substantive contact with a consumer about a specific property. A is wrong because the closing disclosure is the federal treaty document summarizing final loan terms and settlement charges. It is delivered late in the transaction and does not describe the business relationships available between a licensee and consumer. B is wrong because the loan estimate is the federal treaty document delivered within 3 business days of a mortgage application. It addresses loan terms rather than the business relationships available with a real estate licensee. D is wrong because the seller's property condition disclosure is a separate document in which the seller discloses known property conditions to a buyer. It is not the state-prescribed agency relationship statement the licensee must deliver. In New Jersey, licensees must provide a state-prescribed document called the Consumer Information Statement, or CIS, at the very first substantive contact about a specific property. This document exists so consumers can make an informed choice about their business relationship before any representation begins. The CS walks through each recognized relationship in plain language. Seller's agent, buyer's agent, disclosed dual agent, and transaction broker. It identifies the duties tied to each arrangement and invites the consumer to choose the relationship that fits their situation. Delivery happens at the first showing, in person or electronically. After reviewing the CS together, the licensee answers questions, and the consumer's chosen relationship is then memorialized in a written business representation agreement. A common exam trap is confusing the CIS with 3 other documents. The closing disclosure summarizes final loan terms at closing. The loan estimate covers loan terms early in the mortgage process. The property condition disclosure covers the seller's known defects. Only the CIS is the state-prescribed agency relationship statement delivered at first substantive contact. When an exam question mentions business relationships, types of agency, or first substantive contact, the answer points to the consumer information statement, not a loan document, not a seller disclosure, but the informational front door to every New Jersey real estate relationship. Question 50. A working farmer in Hunterdon County keeps at least 5 acres in active agricultural use, satisfies a statutory minimum annual income from farm products, and applies for preferential property tax treatment. Which New Jersey statute provides for that reduced tax assessment for qualifying farmland? Your options are A. The Realty Transfer Fee Act, B. The Pinelands Protection Act, C. The Highlands Act, D. The Farmland Assessment Act of 1964. Take a second. Which answer would you pick? The correct answer is D. The Farmland Assessment Act of 1964. D is correct because the Farmland Assessment Act of 1964 grants preferential assessment to land in active agricultural or horticultural use that meets statutory acreage and income requirements. The reduced assessment is recaptured through a rollback tax if the use changes. A is wrong because the Realty Transfer Fee Act imposes a fee on the recording of deeds at closing. It is a revenue statute tied to transfers. not a property tax preference for active farm operations under qualifying acreage and income thresholds. B is wrong because the Pinelands Protection Act regulates development inside the Pinelands area through the Pinelands Commission. It is a land use statute rather than a property tax preference, and it does not by itself reduce assessments for active farmland. C is wrong because the Highlands Act protects the Highlands region in northwest New Jersey through development limits administered by the Highlands Council. It is a regional land use program, not a tax abatement statute, and does not turn on farm acreage thresholds. The Farmland Assessment Act of 1964 is New Jersey's preferential property tax program for active agricultural and horticultural land. Rather than taxing farmland at its development market value, the Act anchors the assessment to agricultural productivity, keeping working farms financially viable in one of the most development-pressured states in the country. To qualify, a property owner must meet 3 statutory tests: at least 5 acres in active use, a minimum $1,000 gross income from farm products, and an annual application filed with the municipal assessor documenting qualifying use and income. Without the Act, New Jersey's intense suburban development pressure would push property taxes, assessed at full market value, far beyond what farm income could support. The Act shields active farms by valuing the acreage on what it produces agriculturally, not what a developer would pay for it. If the land leaves active farm operation, sold for development or converted to a non-qualifying use, a rollback tax is imposed. It recaptures the difference between the farmland assessment and full market value assessment for the current year and the 2 preceding years, ensuring the benefit supports real farming, not land speculation. 3 commonly confused statutes each serve a different function. The Realty Transfer Fee Act is a revenue measure tied to deed transfers. The Pinelands Protection Act and the Highlands Act are regional land use programs controlling development. None of them provide a property tax preference tied to active farming.
You have reached the end of our first question set. For the free complete exam preparation, visit our website, link in the description, where you find thousands more practice questions and comprehensive study guides. Thanks for studying with us today. See you in the next video.